When traveling the world, you're not just looking for any agency.
Click a Brain has been completely rebuilt. Meet Brain 2. Now, work is easy. All I have to do is ask what I should do next, and then it does it for me. And it suggests how it should do it. And the best part is,
Mr. Khan,
The
never
effect
ever
as we
testify.
sit here now,
So that's a
is that
serious issue
even
that needs to be dealt with.
on
I'm
a
not
later
sure I
date to
agree
which
with
we
that
may
characterization,
postpone,
Chair,
we
but
will
I
be told
accept
the
the
same
point
thing.
that you
So
make, that
ultimately the effect will
postponement
exactly be
as to
what I'm
whether or
saying,
not
which
it's
is
by
that
a
Mr. Karim will
postponement to
never
a
ever
fixed date,
testify.
as
Well, I
opposed
don't know
to
if I
a
agree with the
postponement
characterization
not to a
that
fixed
you'll
date, but
necessarily
subject
be
to
told the same thing. Because
with
what you'll
we have
remember from
before
the
us,
treating
the
doctor's report
the
to
effect
you,
as we sit
and
here
again,
now
I'm not going to go
is
into
that
the specifics
even
of that in light of the
on
ruling
a
on the
later
in-camera
date to which we may
issue.
postpone,
But
we
what
will
the
be told
treating
the same
doctor
thing.
says is
So
that
ultimately the
the
effect
position
will
of my
exactly be what
client
I'm
is
saying,
dynamic
which is
and
that
it is subject
Mr.
to
Karim will
change.
never ever
And that's
testify.
why one of the
Well, I
things
don't
that
know
the
if I
treating
agree
doctor
with the
himself
characterization
proposes
that is
is
to
you'll
account to the
necessarily be
Commission
told the same
under
thing,
oath
because
once
what
every
you'll
2
remember
weeks
from the treating
to update
doctor's
the Commission
report
regarding the
to
client's
and
position,
again, I'm not
and
going
whether
to go
he can
into
or
the
cannot
specifics
testify.
of that in light
It's
of the
also
ruling
why
on the
the
in-camera
doctor's
issue.
evidence under
But
oath
what
is
the
to
treating
suggest
doctor says
that
is
there
that
are alternative
the
means
position
that can
of
be
my
explored.
client is dynamic and it is subject to change.
Oh no, continue.
And that's why one of the things that the
Oh, I
treating
wanted to
doctor
say,
himself
based on
proposes
what
is
we
to account to
have,
the Commission
an
under oath once
educated,
every 2 weeks
guess
to update the
would,
Commission
lead
regarding
one
the
to
client's
say,
position
even though
and whether
you've-
he can or
you've-
cannot
you've
testify.
just made,
It's
the
also why
submission that
the
you've
doctor's
made. We can't hold
evidence
our
under oath is to suggest
No, fair enough.
that there
But-
are
but I was
alternative means
responding
that
to the
can be explored.
characterization
That
Yes,
you'll
yes.
necessarily be
Yeah,
told the
oh,
same
no,
thing
continue,
in future.
continue.
It was
Yeah.
simply to say
Oh,
that
I
that's
wanted
not
to
entirely
say,
correct.
based on what we
You may be
have,
told the same
I
thing in
guess
future, but you may not be
educated,
as well.
I guess I'm saying
guess
exactly the same thing I
Yes.
said earlier when I
lead
say
one to
we
say-
can't really hold our
No,
breath,
indeed
even
so,
though
indeed so.
you've just made the
Can I also
submission
just
that
check
you've made.
the,
We can't hold our
your
breath.
characterization of
No,
when,
fair enough.
how,
But I
how
was
we got
responding
here.
to the
You
characterization
say
that
the
you'll
application
necessarily
for
be
pos- for
told
the
the same thing in
postponement is not
future.
opposed.
It was simply to say that that's not
I don't see
entirely
that
correct.
that is
I
correct.
guess-
You
correct
may be told the
proposition.
same
I
thing in
guess
future, but you may
asking
not
for
be
a
as well.
I guess I'm saying
postponement to an
exactly the same thing I
indefinite
said
Yes.
earlier when I
which is
say we
completely
can't really hold our
subject
No,
breath.
indeed
to
so.
what
Indeed so.
the treating
also
medical
just check
person
your
characterization
is
of
going to determine
when,
whether
how
he ever
how
comes
we
back
got
and on
here.
what date he comes back.
You
But
say
more
the
importantly,
application for
you're bringing an
postponement is not
application
opposed
for a deferral.
I don't see that that is
of
correct.
Mr. Karim's
correct
evidence
proposition.
to
You
an
asking
undetermined
for a
date. That's your
postponement to
application,
an
as I understand
indefinite
it.
date,
And the
which
evidence
is
leaders
completely
oppose
subject
that.
to
And
what
in their
the
opposition, they
treating,
say we want him to come back on a
medical
specific
person,
date. So there is an opposition to
is
your
going to
application.
determine
Yes,
whether he ever
it's
comes
a
back
limited,
and on what
that's
date
the
he
word
comes
they
back.
use in their
But more
correspondence of
importantly,
about the
you're
23rd
bringing
of July,
an
if I'm not
application
mistaken, where they say
for
it's a
a
limited
deferral
opposition. And
of
it's,
Mr.
if I can
Karim's
say this,
evidence
the
to an
difference between my learned
undetermined
friend and
date.
myself
That's your
is the
application, as
mechanics
I
of the
understand it.
postponement.
And the
What's not
evidence
opposed
leaders
is that a
oppose that.
postponement is
And-
appropriate
and
now.
in their
It's just
opposition,
subject
they
to
say,
whether,
we want him
as
to come back on a
Commissioner
specific
Baloy
date.
correctly
So
says,
there is an
it's
opposition to your
open-ended date
application.
or it's a fixed. Yes, and that's what I was saying. It's a limited. That's the chairperson word as they well. use in their So correspondence
it's not to say
of
that
about
it's
the
no
23rd of
opposition
July,
in the
if
sense
I'm
that
not
there's
mistaken,
no
where they say
disagreement.
it's a limited
There is
opposition,
disagreement,
and
but it's on
if
the
I can say
mechanics
this,
of the
difference
postponement
between my
rather
learned
than
friend and myself
the narrower
is the
question
mechanics
that I
of the
was addressing,
postponement.
which is that
What's not
the
opposed is that
postponement
a
being sought
postponement
today
is
in
appropriate
principle
now.
is unopposed
It's just subject to whether
the Commission
as
and ourselves.
Commissioner Baloy correctly
But
says,
if it was
it's an
being
open-ended
opposed
date or it's a fixed
in the
date, and
wide
that's what I was
sense,
saying
whatever
to
that means,
the chairperson as well.
the
So
consequence
it's
would
not
have
to say
been
that it's no
that if it was
opposition in the
opposed and
sense that
opposed
there's no
successfully,
disagreement.
the
There
consequence
is
would have been that
disagreement,
he
but
comes
it's
and
on the
testifies
mechanics
today.
of the postponement rather
He's not going
than the
to. He's
narrower
not here.
question that I was addressing,
So
which is
the
that the
distinction is a
postponement being
technical
sought
decision
today,
really, which
in
makes no
principle, is
difference
unopposed
whatsoever.
between the
Fact of the
Commission
matter
and
is,
ourselves.
You are seeking his evidence
if
to
it
be
was
deferred.
being opposed
We are here today.
in the wide sense, whatever
you
that
say
means,
indefinitely.
the
They say
consequence would have been
no,
that
he's
if
not
it was
getting
opposed and
the
opposed
postponement
successfully,
that he wants.
the consequence
want
would
him
have
to be
been that he
given a
comes
date
and
to come and
testifies
appear.
today.
So, I don't
and
he's not going to. He's not here.
Technical
So
differences, but
the
at this
distinction
point, I
is a
wasn't
technical
engaging
decision really
on the
which
technicalities
makes no
of
difference whatsoever.
indefinite.
Fact of the
I'm
matter
simply saying,
is,
but
this
you are
application is
seeking his
opposed.
evidence to be
That's the
deferred.
position.
Your
We are
application
here today.
is formulated by you.
You say indefinitely
Is being met with an
they
opposition.
say
Yes, it's described as a
he's not
limited
getting the
opposition in
postponement
paragraph
that he
1.14
wants.
of the
We want
attorney's
him to be
letter
given a
on
date
behalf
to
of the
come and
Commission
appear. So
of the
I
23rd of
don't
July. So
understand
that's where I was
the
going to focus the bulk of my
differences, but at
submissions
this
on
point
the
I wasn't
limited
engaging
nature of the
on the
opposition
technicalities
rather
of-
than whether
of
or not a
indefinite and
postponement
impasse,
today
saying, but this
ab
application
initio
opposed.
is being
That's-
opposed. I
that's the
think that's
position. Your
where I'm
application
directing
as
myself,
formulated
Commissioner
by you.
Baloy.
Yes, all right. Is being
But
met
you
with an
accept it is
opposition.
opposed?
Yes, yes, described
within
as a
the
limited
confines of
opposition in
what I've said.
paragraph
Yes,
1.14
absolutely,
of the attorney's
I'm
letter
not-
on behalf of the
it's like in
Commission
litigation
of
where
the
the
23rd
parties
of July.
might-
So
Please,
that's where I was going
you-
to focus
please
the
go
bulk
ahead.
of my
No, thank you.
submissions
I'm
on the
indebted.
limited nature of the opposition.
so by
rather
means of
than
introduction,
whether or
that's
not
the
a
first of the 12
postponement
points I
today
wanted to make.
ab initio is being opposed.
The
I think
question in
that's,
front of
that's
you
where
is
I'm
actually a
directing
narrower
myself,
question
Commissioner
about
Ballard,
Yes,
the
all right.
mechanics of this
But you
postponement
accept it is
and
opposed.
what
Yes, yes,
ultimately
within the
looks
confines
like.
of what I've
whether
said.
it's
Yes,
to
absolutely,
a fixed
sir.
date or whether it's to
I'm
an
not-
indefinite date.
It's like in litigation
And
where
what
the
I will
parties
say,
might.
Please,
the
I think,
Commission in that regard
please go
is
ahead.
two
No,
things.
thank you.
Number one,
I'm indebted.
you have our
So
submissions
by means
on
of
paper
introduction, that's the first of
justifying
the
why
12
it
points
should
I wanted
be
to make.
an indefinite
the-
date.
the question in
But
front of you is
obviously
actually a
the Commission,
narrower
through
question
the evidence
about
leaders have the
put
mechanics
up
of
a
this
series of
postponement and
considerations
what it ultimately
as to why it
looks
should
like.
be to a limited
whether
date.
it's to
And-
a fixed
and
date
practically
or whether
speaking,
it's
that's
to an
something
indefinite
that-
date. And
Excuse me,
what I will
practically
say
speaking, that's something
to the
the
commissioners
commissioners
will
will
apply
apply
their
their
minds to and make
is
two
two
rulings.
things.
Number one,
And
you
all
have
all
our
I'm going to
submissions
say
on
is that the
paper
mechanics of that
justifying
ruling
why it should be
will be whatever it is.
an indefinite
Uh,
date.
I'm not trying
but
to-
obviously
I'm not
the
going to
commission
focus my
through the
submissions
evidence leaders
on
have
the-
put up a series of
the
considerations
harder element, if
as
I
to
can call
why
it
it
that,
should
which
be
is to
to
say it
a
should be
limited
to an
date,
absolute
indefinite
and
date.
practically
I'm
speaking,
going to
that's
focus
something
on my
that-
submissions on the
Excuse me,
appropriateness of the
practically
postponement
speaking, that's something
in the
the commissioners will apply
circumstances
their
in
minds
light
to and make
of
a
the
ruling
evidence
on.
that you have
And
in
all
front of
I'm-
you.
all I'm going
so
to
that's
say
where
is that the mechanics
that's what
of
I'm
that ruling
going to focus on
will be whatever it is.
Can I just say that
I'm not trying to. I'm not going
and the
to
reason
focus
for
my
that is because of
submissions
the
on
limited
the-
nature of this opposition. but I'm not going to
the
repeat
harder
myself.
element, if I
Can
can
I say
call
on the
it
second
that, which
point,
is to say it
please,
should be to an absolute
that there are
indefinite
two
date. I'm going to
potential
focus on my submissions
directives
on the
that
appropriateness
we
of the
would ask
postponement
the Commission
in the
to consider
circumstances
granting
in light of
in respect
the
of
evidence
the
that you have
proceedings today
in front
and the
of you.
argument as it unfolds
So
in
that's
front
where
of you
I'm.
today.
That's what I'm
and before my
going to
learned
focus
friend
on.
has an opportunity to
Can I
address
just say
you.
that the first one
And the
is
reason
that
for that is because
I'm
of the
not sure
limited
what the
nature of this
status of
opposition, but
these
I'm not going to repeat
application
myself.
papers will be.
Can I say
or
on the
become
second point, please,
once the Commission
that there
makes
are
its
two
decision on the
potential
postponement.
directives,
But the
that
request is
we
that should
would ask
any
the
part
Commission
of the
to
record
consider
become
granting
public,
in respect of the
that it is
proceedings
subject
today
to
and
the
limitations
limitations
as it
already
unfolds in front
imposed
of
by
you
the
today,
chair
and
in the
before my
in-camera
learned friend
ruling.
has an opportunity
So that
to
is that
address
the
you.
record of papers
The
itself
first
must
one
not
is that
reveal or
I'm
identify
not sure what the
very
status
things
of
that
these
the chair has
application
said
papers
we're not
will
allowed to
be
say
or
in the oral
become
argument,
once
because that would
the Commission makes its
effectively
decision
render that
on the
ruling
postponement.
pointless.
But the
if
request
paper
is that
record
should
reveals
any
the
part
very
of the
things
record
that we aren't
become
allowed to refer
public,
to in the oral
that
hearing.
it is
I don't think
subject
that should
to
be
the
controversial.
limitations
That's
already
actually
imposed
asking for
by
a
the
logical
chair
extension
in the
of
in-camera
the chair's
ruling.
ruling as it
So that
applies
is
to the
that the
papers.
record of papers itself
The
must
second
not reveal
directive,
or
and this might be
identify
the more
the very
controversial
things that the
one,
chair has
is
said.
I know
we're
my
not
learned
allowed to
friend
say
has
in the
given
oral argument
me advance
because
notice
that would
that she intends to
effectively
rely on
render
certain
that ruling
CCTV
pointless
camera
if
footage.
the
I don't
paper
know if that
record
is still
reveals
the
the
case.
very things that
But
we aren't
there
allowed
are
to refer
other
to
pieces of
in the oral
information
hearing. I don't
that
think
the
that should be
Commission has
controversial.
subsequently
That's actually
shared with
asking
us
for a logical extension
that
of the chair's
may
ruling
also
as
need
it
to be
applies to the
treated
papers.
carefully.
The
In
second
particular,
directive,
there
and this might
is
be the more controversial
mobile
one,
data
is
I know my learned
geolocation
friend has given
information,
me advance
which
notice that
may
she
or may
intends
not
to
be
rely on
projected. I
certain
don't know if my
CCTV
learned friend
camera
intends to
footage.
project
I
it
don't
on
know
the
if that is
screen
still the
when
case.
she makes her submissions.
But there are
But if she
other
does,
pieces of information
the point
that the
that
Commission
I would
has subsequently
request the
shared with
Commission to
us
please
consider
that
and make a
may
directive
also
on
need to be treated
is some of that
carefully.
information
In
contains
particular,
highly specific
there
GPS
is
coordinates,
mobile data,
and the reason that when it is
geolocation
projected
information,
onto the Commission's
which
screen,
may
if the
or may
Commission
not
intends
be
on
projected,
doing
I
that,
don't know if my learned
to
friend
prevent
intends to
the
project it on the
publication
screen
of exact
when she makes her
GPS
submissions.
coordinates.
But
is
if she
because
does,
it
the
opens the
point
threat
that
that
I
the
would GPS coordinates when projected onto the screen can be used to reverse engineer exact some of that information contains highly specific GPS coordinates. Puts my client at a
And the
Durbanville
reason
mall,
that
I
when
can
it is
hardly
projected
complain
onto
about
the
that,
Commission's
but
screen,
I'm
if the
raising
Commission
a
intends on
concern
doing
in
that,
respect of the
to
facility,
prevent
for example,
the publication
and
of
geolocation
exact
data
GPS
near the
coordinates,
facility, is because
I would also humbly
it opens
request
the
that
threat
in
that the
making such a
GPS
directive,
coordinates, when projected
my
onto
learned
the
friend
screen,
is going
can
to
be used
refer
to reverse
to or
engineer
reference
exact
the suburb
locations.
that
Obviously,
the
if the
facility
CCTV
is located
footage
in,
puts
that
my
the name
client
of the suburb
at a
is not
Durbanville
mentioned
mall, I can hardly
explicitly,
complain about
because
that.
it doesn't take a
But
genius
I'm
to run a
raising
Google
concern
search
in
or a
respect
ChatGPT
of
search
the facility,
to
for
ask it
example,
what medical
and
facilities are
geolocation
in the
data near
particular
the facility
suburb.
I
With
would
the effect
also humbly
that
request
it
that
gets
in
close
making
to the
such a
very things
directive,
that the chair has
when my
said
learned friend
should not
is
be
going
identified.
to refer to
So,
or reference.
I don't know,
the
practically
suburb
speaking,
when
that
chair will make
the
those
facility
directives
is
or
located
consider
in,
them.
that
But
the name
I think
of the
even in
suburb
just
is not
flighting
mentioned
the fact that those are the directives
because
I'm
it doesn't
asking
take
for,
a genius
I'm
to
hoping
run
my
a
learned
Google
friend
search
will approach
or a
it
ChatGPT
with
search
some degree of
to ask it
sensitivity,
what
even
medical
in the
facilities
absence
are
of a
in the
directive.
particular
That's not to say my
suburb,
learned friend mustn't
with the
say what he
effect
wants to
that
say, or
it
gets
use
close
whatever
to the
footage he
very
does.
things
I'm
that
just
the chair
raising
has
the
said
concern
should not be
about
identified.
certain of the information which is not
I don't know,
necessarily
practically speaking,
expressly
when chair will
covered
make those
by the
directives
in-camera
or consider
ruling,
them, might
but
nonetheless
I think
be
even in
utilized
just
to undermine the
flighting
very
the
purpose
those are the directives
of the
I'm asking
in-camera
for.
ruling.
I'm hoping
and
my
that's
learned
the,
friend
the
will approach it
second request
with some
that I
degree
make.
of sensitivity,
Chair, I'm
even
in
in
your
the
hands
absence
as
of
to
a
practically
directive.
whether you want
That's not
to
to
do
say
so.
my
My
learned
learned friend
yes,
mustn't say
for
what she
now,
wants to
please
say
continue
or
with your
use whatever
with your
footage she does.
argument.
I'm just
I don't
raising the
want to
concern
eat into your
about
time.
certain of the
What we will
information
do,
which is
raise
not
this
necessarily
issue,
expressly
before
covered
Ms.
by the
Hassan,
in-camera ruling
starts arguing.
might nonetheless be
indebted.
utilized to
Yes.
undermine
I
the
don't
very
think there's an
purpose
issue with
of the
the
in-camera
first
ruling.
one,
And that's
first one, really, but,
the second
we
request
can't make rulings
that I
of
make.
piecemeal.
Chair,
Yes,
I'm in your
indeed,
hands
indeed,
as to
indeed.
practically whether you want me
I
to
think
go
for
on.
now, yes.
So that's
for
point
now,
number
please
two.
continue
Okay.
with your argument. I don't want to.
Yes.
Please continue.
Into Thank
your
you, Chair.
time.
I'm indebted.
What we will
Point
do,
number
raise
three,
this issue,
now talking about
before
the video
Ms. Hassan,
footage. With all
starts
due
arguing.
respect, I'm indebted.
Yes.
In light of
I
the
don't think there's
affidavits
an
that have
issue
been
with
exchanged
the
between
first one,
the
the
respective
first one,
parties,
really, but, we can't make rulings
I'm going to
piecemeal.
respectfully
indeed,
submit that the
indeed.
video footage is unnecessary today. So that's point
And
number
more
two.
than
Than being unnecessary, it's also not appropriate and
Please
does not
continue.
serve
Thank
a
you, Chair.
legitimate purpose. Point number
And
three.
there are three
Now
reasons
talking
why.
about
The
the
first
video
one
footage
is by and
With all
large
due
the
respect,
allegations
made
by
in
the
light
Commission
of the
have now
affidavits
been
that have been
admitted,
exchanged
answered
between
to,
the respective
and amplified
parties
by my
I'm going
client
to
and the
respectfully
people
submit that the
deposing on his
video
behalf.
footage is unnecessary.
So the
today.
footage is not necessary,
and more than being
because the
unnecessary,
footage
it's also
is not needed to
not
prove
appropriate,
admitted
and
facts.
does not serve a legitimate.
You don't need
purpose.
to lead the evidence to
And there are three reasons
deal
why
with admitted facts.
The
That's
first
point number
one
one as to why
is
it's
by and
inappropriate.
large the allegations made
Point number
by
two
the Commission have now been admitted,
is that
answered to,
the footage
and
is
amplified
an inappropriate
by
form
my
of evidence.
client
in light
and the
of the
people
fact
deposing
that-
on his
and you will
behalf.
know this because this is
So the
dealt with
footage is not
explicitly
necessary because
by
the footage is not needed
my
to
client's
prove
treating
admitted
doctor
facts. You don't need to
that
lead the
things
evidence
like video
to,
footage
and
deal with
geolocation
admitted
footage
facts. That's
or
point number one as to
geolocation
why it's
information
inappropriate.
and so on.
Point number
Does
two
not have clinical value.
Sorry, what
is
noun
that
did you
the
use?
footage
It's inappropriate
is
what?
an inappropriate
It's
form of
inappropriate?
evidence in light of the fact
After-
that,
after
and you will
inappropriate, what's
know
the
this
noun you
because
use?
this is
Oh,
dealt with
inappropriate
explicitly
form
Okay.
of evidence
by
All right, thank you.
my client's treating doctor. That
inappropriate
things
form
like
of
video
evidence
footage
because
and
ultimately what
geolocation footage
underlies
or geolocation
the
information
Commission's
and
concern
so
and
on
the Commission's complaint regarding
does not
my
have
client's
clinical
postponement.
value.
Sorry,
is a
what
medical
noun
issue.
did you use? It's inappropriate
And so this
what?
geodata
Inappropriate?
information or CCTV footage or
After-
whatever
after
it is
inappropriate, what's the noun
on
you
its
used?
own,
Oh, inappropriate form.
not being led
form
through a
of
clinic,
evidence.
a
thank
clinician,
you.
and not being analyzed by a clinician or responded to by a clinician,
inappropriate
is
form of
inappropriate
evidence because
secondary
ultimately
evidence,
what
which is being used to
underlies
gainsay the medical
Commission's
opinion
concern and the
expressed
Commission's
about
complaint
that,
regarding my
that
client's
exact
postponement.
approach.
Are you
is a
talking
medical
about
issue.
Durbanville?
And so this
or-
is
Durban.
geodata information or
Can
CCTV
you
footage
please
or
explain
whatever
your
it
point
is
about
on its
it
own,
relating
not
to
being led through a clinician,
what
and not
may
being
have to
analyzed
be,
by a clinician or responded to by a
attended to by a
clinician
medical
is
practitioner?
inappropriate secondary evidence,
may I just ask Ms.
which is being
Matlanga
used to
for
gainsay
some-
Because let
the
me tell
medical
you why I'm
opinion
asking you
expressed
this. I see
about
it as objective
that,
material
that
which says
exact
he was
approach.
there. Are you talking
Yes.
about? So I don't see the
Durbanville.
connection with
Yes,
what a
Durbanville.
medical
Durbanville.
practitioner might Can you please explain your point?
May I
about,
respond? Give two responses. The first response is that it's also accepted that he was there. So it's unnecessary because it's an admitted fact
attended
between
to
the
by a
parties. There's no
medical
need to lead the
Yes,
evidence.
may I
But the
just ask Ms.
secondary line
Matlanga
of
for
reasoning,
some
Because
and this
let-
is
let
where
me
I
tell
need
you
Ms.
why I'm
Matlanga's
asking you this. I
assistance.
see it as
But
objective
she'll hear
material
me
which says he
in
was
response
there.
to you, Commissioner. I'll
Yes.
give you the
So I don't see the connection
reference after
with
the fact.
what a medical
Is this:
practitioner might
the
have
medical
to
practitioner
say on the
says,
issue.
May I respond?
that
Give two
the
responses.
Commission
The first
relies
response is
on
that
a
it's
bunch
also
of
accepted
evidence
that he
such
was there.
as CCTV
So it's
footage,
unnecessary because it's an
Apple Pay
admitted fact
data
between the parties.
regarding
There's no need
payment
to lead the
accounts,
evidence.
movement
But the
data
secondary line
gleaned
of reasoning,
through geolocation
and this is where I
data.
need Ms. Matlanga's assistance.
And the position of the
But
clinician,
she'll hear me
for reasons
in
that
response
you know,
to you,
which
Commissioner.
are
I'll give you
recorded on the
papers,
the
is all
reference
that
after the fact
demonstrates
is this:
is movement of
the
some
medical
kind.
practitioner says,
But that the movement of
that
some kind, the Commission
fact of
relies
the
on a
existence
bunch of evidence,
the movement
such
of
as
some kind
CCTV footage,
is of no value
Apple Pay data
in determining
regarding payment
the clinical
accounts,
issue as to why the client
movement
cannot
data
attend
gleaned
or
through
attend the commission to give
geolocation
evidence.
data.
So,
And the
point
position
is
of
to
the clinician,
inappropriate
for reasons that
is
you know
that
which are
it
recorded
doesn't
on the
deal
papers,
squarely with all due
is all
respect
that demonstrates
with that clinical issue
is movement of
and
some
particularly
kind.
in circumstances
But that
where
the movement of
clinician
some kind
has raised
the
doubt
fact of the
about why it's
existence
being used
of
in the
the
manner
movement
in
of some
it's
kind
being used is of no value
I get you on your
in
first
determining
point, which
the
is
clinical issue as to why the
why
client cannot
flight
attend
that,
or attend the
footage
commission to give evidence.
if there is
So
no
the point
dispute
is to
about his
inappropriate
location on the
is
day
that
and at the
it
time.
doesn't
I
deal
get your
squarely
point.
with all due respect
I'm not
with
sure
that
that
clinical
one,
issue,
you need the
and
second
particularly
point.
in circumstances
And two,
where the
I
clinician
am
has
not,
raised doubt about why it's being
subject
used
to
in the
whatever
manner
else
in
you may
it's
say.
being used.
I'm not convinced by your second I get you on your first point, which
please
is
continue.
Why
But
flight
I stress that you don't, in the face of
footage,
your first point,
if
I'm
there
not
is no
altogether sure
dispute
that you need the
about
second
his
point.
location
That's
on the
where-
day and
that's-
at the time.
I get your point.
On this issue, I'm not sure that one, you need the second
I-
point. And two,
I think we're ad
I
idem
am
on the
not,
first point. And what
subject
I
to
would say
whatever else you may
is that
say,
if those
I'm
facts
not
are not in
convinced by your
dispute, then
second
needing
point.
to flight the footage
But,
so
please
as
continue.
to prove something that's not in
But I
dispute
stress that
is
you don't,
unnecessary.
in the face of
And
your first
you
point,
see, your second
I'm not
point
altogether
would make
sure that you
sense
need the second
if the
point.
That's
flighting
where- that's-
would be
it's-
for
it's
the
a-
purpose
it's-
of
it's a- on this
showing
issue, it's a
that
very weak point.
by being there,
I think we're ad idem on the first point. And
the medical
what I would say
condition,
is that if those facts are not in
on
dispute, then needing to
simply
flight
does
the
not
footage
exist. If that
so
was
as
the
to
purpose, I
prove something that's not in
understand,
dispute
your point.
is unnecessary.
I'm not necessarily.
You see, your
saying
second
that,
point would
Ms.
make
Hassim is not
sense
going to argue
if
that.
the
I do not know what
flighting
she's going to
would
argue.
be for the purpose
But perhaps
of
until she has
showing
argued that point,
that
as I say,
from
by
where
being
I'm
there,
sitting,
I don't think you need the second point. And I repeat, I think
medical
it's a weak point for
condition,
purposes of
this
this
should
should
not
not be flighted. Simply
Well,
does
let
not
me-
exist.
let me
If
accept
that was
the
the purpose,
invitation
I
then
would
to simply
understand
say,
your point.
my learned
I'm not
friend-
necessarily
Well,
saying
I'm caught
that
between a rock
Ms.
and a
Hassim
hard
is
place
not going
because
to
during my
argue
learned
that.
friend's
I do not know
submissions,
what
she
she's
may
going
flight
to
the
argue.
exact footage to make the
But
exact
perhaps
point
until she has argued that point, as
that
I
chair is
say,
putting to me, which is
from
because
where I'm
he was at
sitting,
X place,
I don't think you
that
need the
brings
second
into
point,
doubt
and
the
I repeat,
medical
I think
evidence.
it's a weak point
And
for
in
purposes
fact, that
of
is the
this
commission's
should
case
not be
because you
flighted.
know in
Well,
their
let me
affidavit,
accept the
they
invitation then
call
to
my
simply
client,
say,
with all due respect,
if my learned
gratuitously
friend-
an inverse
I'm caught
outpatient.
between a rock and a hard place.
So the
because
very
during my learned
attitude
friend
of the
submission,
commission,
she may
through
flight
the
the
evidence
exact
leaders,
footage to make
is
the
not
exact point
to say
that
chair is
oh, this
putting
is a
to me,
benign
which is
piece of
because
evidence
he
he
was at
footage,
X place.
the entire
That brings
thesis
into doubt the
underlying
medical
opposition
evidence.
to the postponement.
And in fact,
and why
that
they
is
want
the
to tie down
commission's
my
case,
client
because
to a
you
specific
know
date
in their
is to say
affidavit,
the fact
they
of these
call
movements,
my client
the
with
fact
all due
of these
respect
payments,
gratuitously,
the fact of
and
that
inverse
he's not
outpatient.
in the hospital all
So
the
the
time
very attitude
brings
of the
into
commission
doubt
through the evidence
the medical
leaders
diagnosis
is
that
not
the clinician has given
to
him.
say,
and that's
that,
the
oh, this is
further
a
reason
benign
as to
piece
why
of evidence
we
the
need
need an independent medical exam.
The entire
so
thesis
if, may I just finish on
the
this
opposition
issue
to the
chair?
postponement,
If
and why they want
my learned
to tie
friend is
down
not
my
going to
client
push
to a
that line
specific
of
date
argument today
is
in
to
front
say
of you,
the
then I
fact
don't
of
need the
these
second
movements.
point. But
The
if my learned
fact
friend
of
is
these
going to push
payments,
that point,
the
then I
fact
do need
of
the
the-
second
that
point,
he's not
even if
in the
Chair says
hospital
he's not
all the
convinced
time,
that it's a strong
brings
one.
into doubt the
Is
medical
just,
diagnosis
to make
that the
sure
clinician
that I
has
will
given him.
not be
And
misunderstood.
that's the further reason as to why
the
we need an
question
independent medical
whether
exam. So if,
Mr.
may I just finish on
Karim's,
this,
yes,
please, Chair?
by all means,
If
movements
my learned friend is not going to push that line of
show
argument
a
today in
pattern
front
that
of
is
you,
at odds
then I don't
with
need the
what
second
we
point.
have been
But if my
told.
learned friend is going to push that point,
It-
then I
that's
do need the
central
second
to
point, even if Chair
the
says he's not
evidence
convinced
leaders,
that it's a strong
case.
one.
So what I
This is
said
just,
earlier, to make sure
did
that I
not
will
suggest
not be
that Ms.
misunderstood,
is likely not to argue
the
such a
question,
case.
but
Whether
I'm making a different point. Mr. Karim's
that case can be
movements
argued without the
show
need to
a
actually
pattern that
flight
is at
the
odds with what we have been
the
told.
footage.
Agreed.
Why not
That's
central
exactly
to
because it's
the
agreed
evidence leaders
that
at
case.
the time?
On
So
the day,
what I said
Mr.
earlier
Karim
was
did
at a
not
shopping
suggest
complex
that
in
Ms.
Durban
Hassan
Hill.
is
Agreed.
So
likely
that
not
point
to
can
argue
still
such
be
a
made.
case.
Agreed.
Or that
But
argument
I'm
can
making
still-
a
but
different
as I
point.
said, whether Ms.
That case
Hassan
can
will
be
actually
argued
want to
without
flight,
the need
footage,
to
we'll
actually
hear
flight
when,
the-
when she says so.
Indeed.
the footage.
Shouldn't we leave
Move
it
on.
there?
Why
and move
not?
on?
Yes,
Exactly
I'm happy to. Can I
because
just
it's
give you one
agreed
reference, if I
that
may?
At the time, on the day,
If you look
Mr.
at
Karim
paginated
was at a
page
shopping complex
94
in
of
Durban
your
Hill.
pleadings
So
bundle in the
that point can still
postponement,
be made, or that argument can still. But as I said, whether Ms. Hassim will actually want to flight the footage, will hear.
Paginated page 94, you'll see the
shouldn't
heading,
we
it's
leave it there and
geolocation
move on?
data
Yes,
and
I'm
its
happy
clinical
to.
Can I just give you
significance.
one reference?
The
if I
basis
may?
for the submission that I was making to
If
you
you
comes
look
from
at paginated
paragraph
page
45 on that
94
page.
of your pleadings
as
bundle
to
in the
why
postponement, flighting that is unnecessary over and above the reason that Chair has already identified that it's not in dispute. So I'll just leave that, if I may.
Paginated page
What Ms.
94,
McNamara
you'll
is
see
doing
the
is
heading,
she's
it's
looking through the
geolocation
Commission's
data
papers
and its
to
clinical
give me the
significance.
reference, the exact reference.
The basis
of
for
where
the
this
submission
debate
that I was
arises
making
from in
to
the way
you
that
comes
Chair
from
posits it
paragraph
to me.
45 on
So
that
Ms.
page.
McNamara will give me that reference shortly.
As to why
Can I also just say
flighting
this
that is
moves me on to point
unnecessary
number
over
4.
and above the reason that Chair has already
23 minutes
identified
in.
that it's not in dispute.
Point
So
number
I'll just
4 is
leave
this.
that, if I
Is that
may.
the medical
What
evidence
Ms.
in front of
McNamara
you
is
from
doing
Mr.
is she's
Karim's
looking
treating
through
the
the
Commission's
Commission's
papers
papers
to
undisputed
to give me the reference, the
on
exact
the
reference
clinical
of where
diagnosis
this
and
debate
the
arises
clinical
from in the way that
observations
Chair
that
posits
Mr.
it
Karim's
to me.
treating
So Ms. McNamara
medical
will give me that
professional
reference shortly.
makes. There is
Can I
an
also
expert
just say this?
report,
This
and I'm
moves
not
me
even
on to
going to
point
mention
number
the
4,
expert's name, put
um,
up by the
23
Commission,
minutes in.
which
Point number 4 is this.
generously
is that
doesn't
the medical
actually
evidence
dispute
in front of you
that
from Mr.
Mr.
Karim's
Karim's
treating
observation
clinician is undisputed.
What it does is it speaks
on
to
the
two
clinical diagnosis
collateral
and the clinical
issues.
observations.
The first
that
one,
Mr.
which
Karim's
with the
treating
greatest of respect to the expert
medical
is an
professional
invention of his
makes,
own, is he talks
there
about
is
an
it
expert
being
report,
inappropriate
and I'm not
for
even
Mr.
going to mention
Karim's
the expert's
physician
name, put up
Mr.
by
Karim's medical
the
practitioner,
Commission,
which
generously doesn't
perform what is
actually
called an
dispute
independent
that
medical
clinical
exam on Mr.
observation.
Karim.
What
That's-
it does
it's
is
referred
it
to in the
speaks to
document as an
two
IM
collateral issue.
The simple point about
The first
that
one,
IME,
which with the
and
greatest
why
of respect
then
to the
it
expert
can't be
is an
used as a
invention
basis
of his
to
own,
impugn,
is he
Mr.
talks
Karim's
about
medical
it being
doctors
inappropriate
clinical
for Mr.
observations.
Karim's physician,
Is Mr. Karim's
Mr.
medical
Karim's
doctor
medical
never
practitioner,
performed an IME?
An IME is an entirely separate form
perform what
of
is
medical
called an
examination
medical
that is
exam
performed in
on
a
Mr.
forensic
Karim.
context,
That's-
where there
it's
needs to
referred
be
to in the document as an
a
IME.
degree of separation.
The simple point
or
about that
independence
IME
between the medical
and why
examiner
then it can't
and the
be used as a
ultimate
basis
patient.
to impugn.
But in this
Mr.
particular
Karim's
instance,
medical doctor's
How do you
clinical
describe
observations.
how
Is
do you
Mr. Karim's
describe
medical doctor never
forensic in
performed
this
an
context?
IME? An
When
IME
you say in
is
this
an
context-
entirely
Or
separate
rather, let
form
me leave out
of
in
medical
this context. How do
examination.
you
Let's say
describe
like that is
forensic?
performed
Chair,
in a
this goes back
forensic
to that
discussion
context
you and I
where
had
there
the
needs
last
to
time.
be
If we were in
understandably
uniform
a
Rule
degree of
36
separation
territory
or independence
and you'll
between the
remember
medical
you and I had the
examiner
discussion about
and the
the ultimate uniform Rule 36 as a parallel mechanism
through which
how do you
examinations
describe
occur
the-
in
how
instances
do
of
you
medical
describe
negligence claims.
Forensic in this
That's the
context?
forensic parallel. When you say in this,
that I would
context,
say
Or rather, let me leave out
the
in
IME
this context.
concern
How do you
arises. Let's say,
describe
like,
forensic?
Chair,
I
this
would
goes back to
understand
that
the
discussion you
rule
and I had
to
the last
be
time.
the
If we were in
vehicle
Uniform Rule 36
in terms of which
territory,
you get to.
and you'll remember
the-
you and I had
whatever
the
it
discussion
is the
about
medical practitioner
Uniform
has
Rule
to do.
36 as a parallel
That,
mechanism
it doesn't
through which examinations
necessarily
occur in
answer my
instances of
question.
medical negligence claims.
Well,
That's the forensic
difficulty in
parallel
answering the question is
that
that
I
I'm
would
trying
say
to distinguish what
the
the
IME
Commission's
concern
expert
arises
report
in.
criticizes.
I would understand the
Mr. Karim's
rule
medical
to
practitioner
be
for
the
allegedly
vehicle
doing and why it's
in terms of
inappropriate.
which you
And
get
I'm responding,
to.
yes.
Let's take, for example,
whatever
let's take
it is the medical
the
practitioner
context
has
of
to do.
criminal
Yes.
proceedings
That,
where the rule you are
doesn't
referring to
necessarily
will not apply at all.
answer
I
my
would
question.
imagine that even in that context, you
Well,
can talk
The
forensic.
difficulty in answering the question is that I'm trying to distinguish
are
what the
involved.
Commission's
So it's on
expert
that
report
basis that I'm saying,
criticizes
how would you
Mr.
describe
Karim's
or
medical
define
practitioner for allegedly
forensic
doing
in a way
and
that,
why
for
it's
example,
inappropriate.
would
And
exclude
I'm responding.
what we
Let's
have
take,
been
for
given
example,
here.
let's take
Why is
the
it
context
not
of
forensic
criminal
here? Proceedings where the rule you are
Because,
referring
and that's
to
the exact
should not
criticism
apply
that
at
the
all. I
Commission's
would
expert
imagine that
attempts to
even in
make
that
is that the
context, you
Commission's
can talk
expert,
forensic.
as we understand
When
it,
medical-
says
when medical
that the
practitioners
treatment
are-
Mr.
are
Karim is
involved.
receiving
Yes.
can
So it's
never
on
be
that
an
basis
IME
that I'm saying,
exercise.
how would you describe
because
or define
he's not,
forensic
in
in a way
inverted
that, for
commas,
example,
independent
would
enough
exclude
of Mr. Karim.
what we have been given
And the point
here?
I'm making is that's
Why is
exactly
it not,
correct
forensic
because
here?
the treating
Because-
doctor
and that's the
is not
exact
performing
criticism
an
that
IME
the Commission's
for some
expert attempts to
forensic
make is that the
independent
Commission's
objective
expert, as we
evaluative
understand it,
purpose says that like under
the
Section
treatment Mr.
79
Karim is
inquiry
receiving
or
can
under
never
a
be
Rule
an
36 type
IME
exercise,
exercise
he is
because
the patient,
he's not
Mr. Karim's own
in inverted
treating
commas,
independent enough.
So he doesn't-
Of Mr.
the point
Karim.
I'm simply making
And the point I'm
is
making
that
is that's
the
exactly
basis
correct
upon which the
because
Commission's
the
expert,
treating
it
doctor
seems,
is not performing
seems
an
to undermine
IME for some
the
forensic
clinical
independent
evidence in front of you
objective
from that
evaluative
doctor
purpose
is to say he's
like
not
under
entitled
Section
to
79
perform an
inquiry
IME,
or
and
under
what
a
he's
Rule
given
36
you is
type
not an
inquiry.
IME.
He is,
and we're agreeing
the
with
patient
that because we're saying
Mr.
Mr.
Karim's
Karim's doctor
own
is doing something
treating
fundamentally
doctor.
different.
So he doesn't. The point
So
I'm
that's
simply
the
making
first point that I
is
was-
that
I was
the
making.
basis upon which the Commission's expert,
Please
it
continue.
seems, the second point
seems
that I
to
was
undermine
making, to the extent
the
that that report is relevant,
clinical evidence
in front of you from that
is
doctor,
that
is to
that
say
report
he's
itself
not entitled
emphasizes
to perform
the
an
role
IME,
to be played
and what he's
by
given
Mr.
you
Karim's
is not an
own
IME. And we're
treating
agreeing with
doctors
that because we're saying
before
the treating doctor
any such
is doing
directive
something
can be given
fundamentally
that
different.
he's subject to the medical examination
So that's
of
the
another.
first point that I
and
was
you can find
I was
that
making.
at Annexure MT1.
Please continue.
The second point that I was making,
MT1,
to the
at
extent that
paragraphs
that report is
18 to
relevant
19
in front of you, is that that report itself emphasizes the role to
And
be
it's
played
also
by
referred
Mr.
to in the
Karim's
evidence leader's
own
submissions at
treating
paragraph
doctors
47.
before any such directive can be given that
So
he's
the very-
subject to the medical
The
examination
very point
of another.
is
to
and
say
you can find that
that
Annexure MT1
the medical evidence of Mr. Karim's doctor
MT1
is unchallenged
at paragraphs
directly.
18 to 19.
To the extent it is challenged, it starts from an incorrect premise.
and it's also referred to in
But
the
even
evidence
if it
leader's
does start
submissions
from
at
the
paragraph
correct premise,
47.
it emphasizes the very point as to the centrality of Mr. Karim's
very
own
point
treating
is
doctor,
to
say that
and Mr. Karim's
the
treating
medical
doctor's clinical
evidence of Mr.
observations
Karim's
as
doctor is
influences in the
unchallenged
future process.
directly. And you know, Mr.
To the
Karim's
extent
treating
it
doctor's
is
clinical
challenged,
view,
it starts
speaks
from
to
an incorrect
Mr.
premise.
Karim's non-ability to give evidence.
But even if
And
it
I'm
does
using
start from the
ability
correct
deliberately
premise, it
because that
emphasizes the very
obfuscates
point
as to
what
the
is
centrality
known to us
of
but
Mr.
not
Karim's own
to the world
treating
at large.
doctor. So,
And
even that
Mr.
report
Karim's treating
ultimately
doctor's
draws
clinical
a point to
observations
say
as it
that
influences any
the
future process.
medical doctor's
And you know
observations
Mr.
who's
Karim's
treating
treating
Mr.
doctor's
Karim
clinical
have a central
view
role to play
speaks to
in any
Mr.
determination in
Karim's
how Mr.
non-ability
Karim's
to give evidence.
And we would
And
say
I'm
that
using
the evidence
ability
speaks for itself and
deliberately
it's unchallenged
because that
in front of you.
obfuscates.
But there are a few
What
more
is
things I'd just like to
known to
say
us
in
but
that
not
regard, if I may. The
the
first one
world at
is,
large. Our learned friends provided us a bundle of authorities. A lot of it draws a point to say that
Before you
the
go to
medical doctor's
authorities,
observations who's treating Mr. Karim
I
have
think
a
the
central
first
role to play
point,
in any
the
determination
doctor
in how
makes,
Mr. Karim
that
is
is Mr.
treated.
Karim's,
And we would say that the
is
evidence speaks
that,
for itself and it's unchallenged in front of you.
and I'm going
But there are a
to
few more things I'd
an
just like to
assessment
say
by
in that regard, if I may. The
independent,
first one is, our learned friends provided us a bundle of
So, Mr.
authorities.
Karim's
A lot of it is
doctor
foreign
says-
authorities.
such
Before
an
you go to
assessment, in fact,
authorities,
I think,
Yes, Chair.
I think the first point, the word
the doctor makes,
position
Mr. Karim's.
So if
is
another doctor is interposed, and I'm going
that
to
will be deleterious
an
to
by an
the
independent
treatment that Mr.
Dr.
Karim is.
So Mr. Karim's doctor says, such an
the first
assessment,
point,
in fact,
or the first
prize is that
no
the doctor
other doctor
uses
should
the word inter. But as I understand it, so if
your expression seems to
another
suggest that I'm
doctor
misunderstanding
is
the
interposed,
situation.
that
But
will
let
be
me continue.
deleterious
You will
to-
respond.
You and I have read each other's facial expressions for a long time now, Judge. You'll know what I'm talking about.
I know.
Correct.
Then the
So
the first
the
point
second
or,
point,
or
as
the
I
first
understand
prize
it,
is that
no other doctor should
if
be interposed.
despite
But as I understand it,
your expression seems to
as
suggest
the
that I'm misunderstanding the situation.
But
But
let
let
me
me continue. You will respond.
You and I have read each other's facial expressions for a long time now, Judge. You'll know what I'm talking about.
Then
I'm paraphrasing
the-
here,
the-
forgotten the actual
the
wording.
second
that
point,
should
as I
be
understand
done
is
in
that
consultation with
if
me. I should be involved
despite
as to
my
how exactly I'm not
opposition
altogether sure now.
as the doctor,
should be done
as the
in consultation with
if
me.
despite that the
Now,
position is
what I
that
wanted
another
to,
doctor should
to
be
raise
interposed,
is that should be
if
done
the
in,
doctor
I'm
does
paraphrasing
say
here,
that
forgotten
as
the
an
actual
alternative,
wording. That should be done in consultation
Would
with me. I
Mr.
should be
Karim
involved as to
oppose
how exactly
this-
I'm not altogether sure now. Should be done.
that is the
in
alternative would
consultation
Mr.
with me.
Karim totally oppose
Now,
it?
what I wanted to raise.
Well, I have no
is
instructions on that, and as you know,
if
the legal
the
team
doctor does say
had to
that
obtain
as an
instructions.
alternative,
in the manner in which you and I
So-
know yes,
so-
how this is.
would
So
Mr.
I would have to
Karim
take an instruction.
oppose
But
this.
if I may, I don't know if you are
That
done,
is the-
Chair, and I
the-
don't
the
want to interrupt
alternative
you.
would Mr.
Yes,
Karim
But
yes.
having
totally-
regard to my
totally
facial
oppose it.
expression earlier, the reason Well, that I have no it was of that instructions on kind that is, and
if
as
you
you
can
know,
go
to the paginated legal pleadings, team
please,
have had to
paginated
obtain instructions.
page
No, in the
49.
manner in which you and I
So-
know yes,
so-
how this is.
So I would have to take an instruction.
Yes.
But
if you
if
look
I may, I don't know if
at
you
the
are
heading
done,
just
Chair, and I don't
above,
want to interrupt you.
Yes,
But
yes.
having regard
just
to my
above
facial
paragraph
expression
68, the
earlier, the
consequence
reason
of
that it
compelled
was of that
attendance.
kind is if you
So
can
I
go
think
to the paginated
how I
pleadings,
fairly
please,
read, how I
paginated
understand
page
the
49
treating
doctor's position is this. And I think, Chair, this goes back to the debate you and I had last time, and can you draw any inference from a compelled
if you
attendance
look
where it's chosen
the heading
not
just
to attend
above,
or a voluntary attendance?
just above
the position
paragraph
of the
68,
doctor,
the
consequence of
is
compelled
that
attendance. It's not to say
So
that
I think
none should be
how I
interposed as a
fairly
blanket
read,
position.
how I
It's to
understand
say
the
none
treating
can be
doctor's
interposed
position is
unilaterally.
this.
Or
And I
in
think,
a
Chair, this
compelled
goes back to the
sense
debate you and I
that
had
the
last
doctor
time.
resists,
And can you draw any
and then the
inference
doctor's
from a compelled
position
attendance
in
where it's
respect
chosen
of not to attend
what
or
then?
a voluntary
So in other words, if
attendance.
it's voluntary,
the
does it
position
come through
of
me
the doctor
or whatever the
is
case might
that
be?
it's not to say that none should be interposed
same
as a blanket
affidavit
position.
It's
It's to say none can be interposed unilaterally or in a compelled sense that the doctor resists. And then the doctor's
For example,
position
he doesn't deal
in
with it in
respect
express
of,
terms, but he's talking about
what
in
then?
paragraph
So
71.
in other words, if
on
it's
page
voluntary,
51,
does it come through me
he's talking about
or whatever the
less
case might
intrusive
be
formats
is
expressly
engagement.
dealt with
and
in
his
that same
ability to manage the downstream consequences of the format ultimately chosen
page 51
as a consequence of what the Commission chooses to do or not do. This paragraph admittedly is talking about, for example, he doesn't deal with it in express terms, but he's talking about in paragraph 71, but it's an answer to you, Chair, about he's talking about less intrusive position is not engagement. And his ability to manage the downstream consequences of the format
I say no,
chosen.
no.
The doctor's position is to say that the Commission chooses to do or not do. And this paragraph admittedly is talking about, which is not clinically detrimental should it be to my clients, my patient's current position or future but it's an answer to you, Chair, I would have to give medical advice in that regard. The doctor's position is not to say that it's not perhaps as blunt as the way in which the Chair was positing it to me. No, it's
Now,
the doctor's
exactly
position is
on
to
what
say that
you've
I
said,
must be
last.
consulted, and if I can facilitate something
My
which is not
question
clinically
relates
detrimental
exactly
to
to
my
that.
clients,
If
my
in
patient's
a
current
sense,
position
even
or
if
future position,
qualified,
then I would have to
the
give medical
doctor
advice in that
is
regard.
not
So
altogether
it's
rejecting
to say that it's
the
not perhaps
idea
as
of
blunt as the
interpolation.
way in which
As
the
I-
Chair
as
was
I-
positing it to me.
Now,
Mr.
exactly
Curran's
on what
position,
you've said,
that I think that's
last.
the point on which you already said you have no instructions.
Yes,
My
yes.
question
If
relates
we
exactly to
were
that.
to say,
If
please
in
get
a
instructions,
sense,
when
even
would we-
if
by when would we
qualified,
get a response on that?
the doctor
I can't
is
commit
not
because it would have to be
altogether
relayed
rejecting
to the
the
two
idea
individuals who
of
would then have to engage
interposing another doctor.
with Mr. Karim when he's
What
available
would
and then
Mr.
have to come
Karim's
back to
position
us
be? And
as
that-
the
I think that's the
legal
point on
team.
which you already said.
As you
have
know,
no
one of the
instructions.
issues are is that in present circumstances, we don't have
If
direct
we were
access.
to say,
But
please
I would
get
imagine,
instructions, when
on
would
my
we-
understanding
by
of the
when
protocol,
would we get a response on
the
that?
existing protocol,
I can't commit because it would
surely
have
there
to be
must have been a
relayed
good
to
few
the two
interactions,
individuals who would then have to engage
following that protocol.
with Mr. Karim when he's
I would
available
I would
and then
imagine
have to
that
come
should
back to
give
us
you an
as
idea
the
of possible
legal team.
timeframes.
As you know, one of the issues are is that in present circumstances,
No,
we don't have
because in as
direct
much as I
access.
thought
advocates
I
were
would
busy and have
imagine
busy
on my
diaries. I've never
understanding of the
dealt with
protocol,
medical
the
professionals whose
existing
diaries are
protocol,
even more challenging than ours.
surely there
And that's
must
why,
have
you know,
been a
for
good
example,
few
some of our papers
interactions,
reached late because of when
following
we could
that
consult with
protocol.
the medical
I
professional
would
in
imagine,
particular
I would imagine
concern.
that should give you
Can
an
I say
idea of
this?
possible timeframes.
In principle, on what's in front of you,
No,
and what the
because
doctor
in as much
himself
as I thought
has said,
advocates were
there
busy
should
and
be
have
no
busy
objection.
diaries, I've never
But
dealt
that's
with
obviously
medical
subject to his
professionals
ability
whose
to speak
diaries are
on
even
behalf
more
of Mr.
challenging
Karim
than ours.
with or without Mr.
And
Karim's
that's why, you know,
consent.
for example,
some of our papers reached
whilst
late
maybe
because of
my
when we
learned
could
friend
consult with,
is on
the medical
her feet,
professional
so
in
to speak,
particular
proverbially.
concerned. Maybe what I can
I-
ask is
can
Mr.
I say
Bismillah,
this?
who's sitting behind me, and from my
in principle,
instructing firm
on
of
what's in
attorneys,
front of you
can
and what the
try
doctor
and
himself
get in touch
has
with.
said,
There should be no objection.
our other attorneys
But
and the
that's
relevant
obviously subject
individuals
to
to
his
try and take
ability
a
to
specific
speak on behalf of
instruction
Mr. Karim
on what
with or
Chair
without
has put
Mr.
to me.
Karim's consent.
That's the best I can offer in the
circumstances.
circumstances.
Whilst maybe my
I
learned
must
friend
make
is
the comment
on
that
her feet, so to speak,
what
proverbially,
you've just said
maybe
now
what
is
I can
quite
ask is
useful,
Mr.
which is
Bismillah,
that
who's sitting
there is
behind
no
me and from my
in principle
instructing
objection
firm of
to the
attorneys,
idea.
can
Well,
try
because
and
fr-
get
from my
in touch
reading of
with,
what the doctor has said,
our
is
other
his-
attorneys
his
and the relevant
opposition in
individuals to
inverted
try and take a
commas was
specific
on the
instruction
unilateral
on what
imposition
Chair has
of
put to
a
me.
third-party medical
That's the best I
practitioner.
can offer in the
But the
circumstances.
doctor has himself
I
spoken
must
about less
make the
intrusive
comment
means in a
that
multiple
what
in a
you've just
multitude
said now
of
is quite
manifestations.
useful, which is that
And
there is
if,
no
if the doctor
in principle
interposing
objection to
in
the
respect
idea.
of a
Well,
third
because
party
from-
to
from my
obtain
reading of what the
voluntary
doctor has
consent,
said,
is
his-
whether it's
his
given or not
opposition in
given,
inverted
is within the
commas was
basket
on
of those
the
less intrusive
unilateral
means,
imposition
as I see it,
of a third-party
because it's not
medical
the
practitioner.
compelled examination.
But the doctor has
And so that's why I say in
himself spoken
principle,
about less intrusive
I don't
means
understand
in a
that
multiple
that could be an issue, but
in a
I will ask
multitude
Mr.
of
Bismillah to get the
manifestations.
specific instruction. And
Thank you.
if the
Please
doctor
continue.
interposing
Moving on to
in
another
respect
point.
of
Sorry,
a
before-
third
before-
party to obtain
Yeah, before you move on,
voluntary
let me just
consent,
clarify. You and the chair
whether
seem
it's
to
given or
be
not given, is within
of
the
a common
basket of
understanding
those
of
less
what the
intrusive
doctor is
means,
saying.
as I
So
see it,
maybe I
because it's not the
misunderstand.
compelled
I'm
examination.
looking at
And so
reading
that's
from
why I say, in
73.1
principle, I don't
up to
understand that that
73.3.
could be
I
an issue, but
understand
I
the
will ask
doctor
Mr. Bismillah to get
to
the
say
specific
that
instruction.
there must
Thank
first be
you, thank you. Please
engagement with
continue.
him.
Are you moving on
these
to
matters.
another point?
I see Commissioner Beloy.
Yeah, before you move on, let me just clarify. You and the chair
paragraph
seem to be
73.2,
what is clinically objectionable
May I
and
ask for the
understanding
page,
of what the
please,
doctor
Commissioner?
is saying.
52. Thank you,
So it
Commissioner.
may be I misunderstand. I'm looking at reading from 73.3, but the up to clarification that I would like to have
understand the
is
doctor
because of what he said in 73.3,
there must first be
he says
engagement
a
with
properly
him
constituted
on these medical
assessment
issues.
stands in a
And
different
if we are not
footing.
happy, if
I'm
after
reading now
engaging
at
me,
paragraph
the commission
73.2,
remains
what is clinically
unsatisfied.
objectionable,
May I ask for the
I do
page,
not
please, Commissioner?
object
Sorry,
in
52.
principle.
Thank
So,
you,
52.
Commissioner.
On the doctor's offer,
73.1 up to
anticipates
73.3,
given a
but
report,
the
then he must
clarification
be
that I would like to
engaged
have
with
is
about
because
his
of what he
report.
said in 73.3,
by the
he
commission.
says a properly
And-
constituted
and if
assessment
land at
stands in a
not being
different
satisfied,
footing. If
out
after
of our
engaging me
engagement with him,
the commission
arising
remains
from his report,
unsatisfied, then he
I
does
do
not
not
have an
object
objection
in
to
principle.
the
So,
interposition
on the
subject to whatever he
doctor's
says there.
offer,
I understand
he
you and the
anticipates
chairperson
he's
to
given a
have,
report,
then he must be
formulated
engaged
as
with
follows, about
that as
his
matters
report.
stand, the doctor does not have
By
an,
the
an
commission.
objection to an
And-
interposition,
and
provided
if
there's a condition.
land
the
at
conditions
not
in there.
being
Am I
satisfied,
misunderstanding?
No,
Out
no,
of our
we were past
engagement
the
with him
original
arising from
stage, which
his
is
report,
about the conditionality.
then he does not have an
I was on
objection
what I
to
referred
the
to
interposition
as the
subject
faulty
to whatever he
position,
says
as
there.
it were, and I don't think
I
it
understand you and the
differs from what you've just
chairperson
said.
to have formulated.
I think we're
as
all
follows.
ad
That as
idem
matters
because
stand,
Commissioner
the doctor does
Baloy,
not have an
you
objection
looked
to an
at
interposition, provided there's a condition, the conditions in there.
Perhaps, I think
No,
Commissioner,
we were past the
Commissioner
original
Valo has just said,
stage, which is about
yes.
the conditionality.
When I made the, I think
I
you
was
should
on
move
what I
on to
referred
to another
as the
point
faulty
if you are
position,
about
as
to.
it were, and I don't
Okay.
think it differs from what you've just said.
I don't want you in the end to say the
think
the
we're
hour was
all
too short
ad idem
because of our
Commissioner
engagement.
Baloy,
Could I,
you look
all I'll say
at,
to Commissioner Baloy, if I may, is I know Commissioner, you looked at
Perhaps,
73.3.
I
When-
think Commissioner, but
You probably
Commissioner
have looked at
Valo
it
has
already,
just
but the
said,
way in which I would
yes.
look at what he's
When I
saying
made
in
the- I think you should move on
73.3 follows
to another
on
point if
70,
you are about to.
particularly 73.1 and 73.2 on the same
I don't want
page.
you in the
But
end
as
to
it
say
relates
that
to that
the
earlier
hour
statement,
was
which
too
is where the
short
chair and I started
because of
about
our
a
engagement.
compelled
could I-
examination.
all I'll say
And I
to
think what
Commissioner
he's
Baloy, if I
addressing
may, is I know
in
Commissioner,
those
you
circumstances is what the
73.3
deleterious
when,
effect of a
you probably
compelled
have looked at it
imposition
already,
of a
but the way in
third-party
which
medical
I would look at what
practitioner
he's
would
saying
be
in
for what he is
73.3,
doing,
but
follows
not to
on
say that that's
particularly
total
73.1
out-
and
outruling
73.2 on the same
of
page.
less
But
intrusive
as
means,
it relates to
provided
that,
that
earlier
whatever the
statement,
less
which is where the
intrusive
chair
means
and I
are,
started
plays
about
a suitably
compelled
respectful role of him as the treating
examination.
doctor.
And I think
which,
what he's
which I said
addressing
at the very beginning,
in those
even the
circumstances
commission's
is
own
what the
expert
deleterious
accepts
effect
that that's
of
the
a
role to be
compelled
played
imposition
by
of a
his treating
third-party
doctor
medical practitioner
I understand.
would be
Thank
for
you.
what
Thank you,
he
Commissioner
is doing,
Baloy.
but not to say that that's a total outruling.
Just so
of
that
less
I was
intrusive
making the
means,
point about the
provided that
authorities,
whatever the less
and I
intrusive means
now see
are,
it's 44
plays
minutes.
a suitably respectful
I'll
role
be
of
quick.
him as the
And I
treating
took only
doctor,
3 minutes
which,
of that
which I
time,
said at the
please.
very beginning.
Don't worry, I'm not
even
going
the
to ask for an
Commission's own
accounting
expert
exercise between the
accepts
commissioners
that
and
that's the
myself.
role to be
But
played by his
very
treating
quickly, if I
doctor.
may, the
understand.
point
Thank
about
you.
unchallenged
Thank you,
medical
Commissioner Baloy.
evidence and proceeding in the face of unchallenged medical evidence. Just And so you know, that
I say
I
that
was
our-
making the point
our-
about
my
the
client's
authorities,
doctor's evidence,
and I
when
now see
properly
it's 44
understood, is
minutes.
unchallenged. That
I'll be
point
quick.
is made
And
by
I
the
took
same
only 3
authorities
minutes of
relied
that
on
time,
by our
please.
learned friends.
Don't worry, I'm not
So,
going
for
to ask for an
example, at
accounting
paragraph
exercise
16
between the commissioners and
of
myself.
the
But
Hyatt case,
very
which can be
quickly, if I
found at
may,
pages 6 and 7
the
of
point
their
about
authority
unchallenged
bundles,
medical evidence,
that
and
point is made.
and
that
proceeding
point is also made
in the
again
face of
later on
unchallenged medical
in that
evidence.
paragraph,
And I say
in that judgment
our,
at 32,
my client's
paragraph
doctor's
32b,
evidence, when
on
properly
page
understood,
12,
is unchallenged. That point
and
is made
interestingly,
by
it
the
says-
same authorities
it says
relied on by
it
our
would be
learned
wrong
friends.
for a committee
So
which
for
has the
example,
livelihood and
at paragraph
reputation of a
16
professional individual
of
in the
the
palms of
Hyatt
its hands,
case
to
which
go
can
with
be
the
found
hearing
on pages
where
6
there
and
is
7 of their
unchallenged
authority
medical
bundles,
evidence that the
that
individual
point is made,
simply not able,
and
that
I'm
point
using
is
the word
also
able
made
to
again
not use the
later
word in the
on in
quotation,
that paragraph,
to withstand
in that
the rigors
judgment
of the
at
disciplinary
paragraph
process.
32b,
And
on page
why
12,
I emphasize that is because
and
you know the
interestingly, it
position
says,
taken by my
it says
client is that
it would be
the
wrong for a
secondary
committee
evidence,
which
the
has the
CCTV
livelihood and
footage, the
reputation of a
geolocation
professional
data,
individual in the
even their
palms
own
of its
doctor's
hands,
report,
to go with a
doesn't
hearing
challenge the medical
where there is
evidence properly
unchallenged
in
medical
the way
evidence that the
medical evidence is in
individual
front of you.
is simply not able, and I'm
I'm
using
not
the word
sure that,
able to
that's
not
a
use
good
the word in the
point,
quotation,
because,
to withstand the rigors of the
I
disciplinary
think at the last
process.
And
appearance,
why I emphasize that is
you
because
strongly
you know
oppose
the
any
position taken
idea
by my client is that
of
the
an
secondary
assessment
evidence, the
by
CCTV
an
footage, the
independent
geolocation
doctor.
data,
So
even their own
on that
doctor's report
basis,
doesn't
there can be
challenge
no
the medical
question of
evidence
us
properly
having
in the way that the medical evidence is in front of
a
you.
report by a doctor. I'm not sure that that's a
what
good
Mr.
point
Karim's, doctor
because
says.
so we all
I
understand
think at
why
the
there is
last,
no opposition.
No, with
It's not as if
you strongly
with
oppose any
an
idea
opportunity available
an
for another
assessment
doctor
by
to
an
counter this
independent
doctor's
doctor.
report. So
On that basis,
no counter.
there can be no
was
question
finished.
of us having
It's on that basis that I
a
feel
report
that's not a
by
strong
a
point at
doctor
all.
I
Challenging
respectfully
what Mr.
disagree with
Karim's,
you, Chair,
doctor
in the
says.
following two
So
respects.
we all
On the last
understand why
occasion, it
there
was
is
not
no
that I had
opposition.
any
No, with
objection
all-
to an
it's not as
independent
if
exam being
with
performed.
an
It was
opportunity
whether or not it could
available
be compelled
for another doctor
and whether or
to
not
counter
any
this
inference could be
doctor's
drawn.
report.
that boils down basically to
No
the same
counter
thing
because
was finished.
in expressing your
It's on that
view that
basis that,
compulsion
I feel
was
that's not a strong
not
point at all.
possible.
I respectfully
The upshot
disagree
of
with
that
you,
was
Chair,
that you
in
were
the following
opposing.
two respects.
That was
On the last occasion,
opposition.
it was not that I had
And you
any
even,
objection to an
that was the
independent
context in which you
exam being
referred to the
performed.
rule
It was
in the
whether or
context of
not it
civil
could be
proceedings.
compelled
You
and
said
whether
you
or not
questioned
any
our
inference could be
mandate,
drawn.
power,
Correct?
boils
that
down
our
basically
legal
to the
power
same thing
because
to even compel.
in expressing
Correct.
your
That's
view that
opposition.
compulsion
Yes,
I don't understand
But then
was
you and I landed
not
on the agreement
possible.
that no adverse
The upshot
inference
of
could be
that
drawn
was
if
that
it's a
you were
voluntary
opposed.
process.
That's something
was-
else.
No, but that's
that's
the
something
point
else.
I'm
And you
making. The point I'm making is
that was the
my
context in which
opposition,
you
so to
referred to
speak,
the
at that
rule
time,
in the
way
context
in
of
which we
civil
understood the
proceedings.
Commission's
You
case
said you
was on the
questioned
issue of the
our
compelled
man-
examination.
power.
Correct.
What
What I'm
the-
saying
our
in
legal
response
power
to
to
this
even
issue as a
compel.
continuation of
That's
what just
opposition.
happened between
So I don't
yourself, Chair
understand
Commissioner
you and I
Malloy,
landed on the
and myself
agreement
as well.
that no
is
adverse
that
inference
if
could be
the
drawn if it's a voluntary
examination
That's something
is the
else.
mechanism.
No, but that's,
No, that's
but that's the
something
point I'm
interposition
making. The
of
point I'm making
Mr.
is
Karim's
of
own
my
doctor or
opposition,
not,
so to speak.
then
At that time,
that would be fine
in the way in
because
which
that
we
also
understood
means
the
that no
Commission's case
adverse
was on the
inference
issue
can
of
be
the
drawn if he
compelled
declines
examination.
to not
What
participate
I'm
in
saying
that.
in
That's where we
response
landed
to
this issue as a continuation of what just happened between yourself, Chair Commissioner Balloy, and myself as well, is that if the voluntary examination is the mechanism with the interposition of Mr. Karim's own doctor or not, then that would be fine because that also means that no adverse inference can be drawn if he declines to not participate in that. That's where we landed the last time.
You are saying something like that for the first time now. I accept that on today the previous you have made the point that you strongly argued against it, making the point that we simply do not have the power, and you distinguish the fact that we do not have instructing the power by making reference to the power that a high court has in civil proceedings in terms of the rules. At no stage did you ever get to a point you are saying something like that for the first time now. We are amenable the previous occasion. We are voluntarily amenable against it, making the point that we simply do not have the power. And you distinguish the fact
debate
that we
didn't
do
get
not
that far
have
with due
the
respect.
power
Where we
by making
ended
reference
and we were having a
to
general
the power
conversation
that a high
is
court
that
has
I
in civil
ultimately
proceedings
accepted that
in
if it
terms
were
of
a
the
voluntary
rules.
process
At no stage
and that
did you
no
ever get
adverse
to a
inference
point
could be drawn
that said
as to
No,
the
no, 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 no.
participation in that
We are
voluntary
amenable,
process,
but
that's where we left it.
We are
Mr. Premier,
voluntarily amenable.
Did you, because
to
an assessment
more than
by
one
another
letter?
doctor?
You never got to that point.
Because
In
that's
fact,
the
at least
debate didn't
two
get
that
that far
I
with due
remember from
respect.
reading
Where
these
we
papers for this
ended and we were
postponement
having a
application.
general
More
conversation
than one letter was
is
written
that I
to Mr.
ultimately
Karim's
accepted that
attorneys
if it were a voluntary
requesting him
process and that
to
no
avail
adverse
himself
inference
for
could
an
be drawn
assessment
as to
by
the
an
participation in that
independent
voluntary
doctor.
process.
Initially, there was no response.
That's where we left it.
But Mr.
And,
Premier,
was there a response the second
did you,
time
because
around? I'm not sure. More than one letter. But here, in fact, at least two that I remember from reading these papers for this postponement application. More than one letter was written to Mr. Karim's attorneys. That's all that we know. So for you to suggest that, however, there could have been the possibility of initially there was no response, agreed to assessment comes as a complete surprise to me. Because the attitude throughout, here, especially in the face of the two letters, commission, that was specifically asking for this assessment by you against that what you say now, possibility. Simply does not all that we know. So for you to suggest that however, culminating in your possibility of a voluntarily agreed to subject himself comes as a complete surprise to me, by now, because the attitude something, especially in the face of the two letters, saying that was specifically asking for willing to subject myself to that assessment. What you say now, that simply does not accord the commission's attorneys have asked for. That history more than culminating in your argument before. So I don't understand your argument. If Mr. Karim was prepared, insofar as it relates to subject himself to the assessment, we should by now have received something from him or his subjecting himself, saying that to the assessment voluntarily. I do not understand that. Not in the face of the history I'm referring to.
No, I accept that,
the
and
commission's
I'm not going to try and
attorneys have asked
relitigate
for
that history now.
more than
I think I'm
once.
going to go and read the transcript.
So I don't
because at this
understand your
stage,
argument.
I'm going to respectfully say recollections
Insofar
may
as it
vary.
relates to
And then I can come back
the-
to you
the-
and
the
reply and clarify
possibility
that
of
as needed, because
Mr. Karim
I'm
subjecting himself
as I say,
to the
I
assessment
remember the debate having
voluntarily.
happened
I do not
slightly
understand that
differently,
part of your
and it
Not
was
in
on the
the face of the history
characterization
I'm referring to.
issue.
No, I
about
accept that,
voluntary
and
or
I'm not going to try and
compelled, and it
relitigate
didn't
that
go
history
beyond
now.
specifics
I think I'm
about
going to go and
what
read
if
the
it's
transcript,
voluntary, then what is
because
the
at this
instruction
stage, I'm
in
going
the
to
way that it
respectfully
was
say
put to me
recollections may
today.
vary.
And in light of the
And
new
then I can
evidence
come back
that has
to you
come
and
about
reply
less
and
inclusive
clarify
means,
that,
that's why I gave
as
as in
needed,
principle
because
answer.
I'm
subject to my instruction.
As I say,
but I'll
I
read the
remember the
transcript
debate
and
having
I will
happened
come back and
slightly
if I'm wrong
differently,
about, and it was
about
on the
that, then obviously
characterization
I will be wrong and I will
issue
apologize
about
to the commission
voluntary
accordingly.
or compelled.
But,
And it didn't
if
go
I can
beyond
move on,
specifics about
what
if it's
just to
voluntary, then
protect
what is the
myself
instruction
from a
in the way
full-on
that it was
egg on
put
my
to me
face. Let me
today.
say I'm
And in
also
light of the new
only
evidence
human
that has
and
come about
fallible.
less
So
intrusive means,
my memory
that's why
may
I
also
gave
be
an in
inaccurate.
principle
Please
answer
continue.
subject to
Well, that's
my
why they have
instructions.
appeal courts. They
But
can
I'll read
correct
the
the
transcript
lower
and
court
I will
judge's
come
memory,
back.
but,
And if I'm wrong about
no, Judge, thank you.
about
I accept
then
that.
Obviously, I will be wrong, and I will
Let me just say
apologize
this
to the commission
the
accordingly.
other
Mechanism
but,
available
if
is
I
that
can
there
move
could
on.
have been, in terms of
just
direct
to
challenge
protect myself
to
from
Mr.
a
Karim's
full-on
doctor's
egg on my
evidence,
face, let me
is
say I'm
that
also
instead of
only human and
the
fallible.
report
So
that was
my
put up,
memory may also
which
be inaccurate.
talks about
Please
the
continue.
subsequent
Well,
process,
that's why
which
they
is,
have
I'm
appeal
going to
courts.
describe
They can
as
correct
collateral.
the lower court judge's
a rebuttal
memory,
witness
but,
could have been brought.
No, Judge, thank you.
And
I
the
accept
rebuttal
that.
witness, like ordinarily happens
let me
in
just
civil
say this.
litigation where there are
the other
contesting
mechanism
expert
available
witnesses,
is that there could have been,
in terms of
which doesn't
direct
necessarily
challenge
involve
to
an
Mr.
inspection in
Karim's
loco
doctor's
per se,
evidence, is
of
that
the incident
instead
or the,
of the report that was put
person,
up, which
is
talks
possible
about
that wasn't done
a subsequent process, which is I'm going to describe
You've already
as
heard
collateral.
me. I was going
A
to take
rebuttal
you through the
witness could have been
authorities, but I
brought.
don't think that that's
And the
necessary.
rebuttal witness, like
for me
ordinarily
to do
happens
so,
in civil
except to
litigation,
refer
where
to
there
one
are
judgment,
contesting
if I may,
expert
which is one
witnesses,
that's cited, I think, by both of us,
which
South
doesn't
African
necessarily
judgment.
involve
It's
an
Michael
inspection
versus
in loco
Linksfield
per
Park
se,
of
2001
the
incident
volume
or
3,
the
SA 1188
person
SCA
is
at
possible
paragraph
that wasn't
39
done
in
either.
particular.
I just
You've
gently
already
point
heard
out
me.
that there the
I was
SCA
going to
said
take
the
you through
assessment
the
of
authorities,
medical
but I don't
risks
think
and
that that's
benefits
necessary
is a matter of
for me to
clinical
do
judgment,
so,
except
except
to
to
refer
refer
to
to
one
one
judgment,
judgment,
if I may, which
to
is
make
one that's cited, I
without
think, by
expert
both of
evidence.
us, And so that's
South
the
African
point that
judgment.
I'm making.
It's
And so
Michael
far as
versus
there's direct
Linksfield
medical
Park, expert evidence in front of you is
volume
concerned.
3, there is no rebuttal of that.
1188
It remains
SCA
unchallenged.
at paragraph
and
39 in particular.
The Commission should be slow
just gently
to
point
draw
out
any
that there the
inferences
SCA
from
said the
alternative
assessment of
sources
medical
of
risks
evidence
and benefits
as to what
is
clinical
a matter of
value
clinical
it has
judgment
or it
which the
doesn't
court
have.
would
Because
not
that
normally
alternative
be able
evidence
to make
is
without
not
clinical
expert
evidence. And with
so
all
that's
due
the point
respect,
that
you
I'm
don't have
making. And
a
so
duly
far as there's
qualified
direct
clinician
medical
in
expert
front of
evidence
you in front
who
of you
offers
is
an
concerned,
alternative view
there is no
about
rebuttal
Mr.
of
Karim's
that. It
clinician's
remains
view of
unchallenged.
Mr. Karim.
And
in fact, the
expert
Commission
report
should be
put
slow
up
by the
to
Commission
draw any
itself
inferences from
expressly
alternative
qualifies
sources
itself
of evidence
by saying
as
I
to
don't
what
offer
clinical
an
value
opinion
it
on
has
the
or it doesn't
underlying
have.
medical
Because
assessment
that
made
alternative
by that
evidence
clinician.
is not
So,
clinical
insofar
evidence.
as
And with
the
all due
clash of
respect, you
evidence
don't
and the
have
weight to be
a
attached
duly
to the
qualified
evidence is
clinician
concerned
in front
in
of
the
you
exercise of
who
your
offers an
discretion as to
alternative
whether
view
a
about
postponement
Mr.
should be
Karim's
granted.
clinician's
I come back
view
to the
of
point
Mr.
that
Karim.
the stronger
In
evidence
fact,
is Mr.
the
Karim's
expert
clinician's
report put
direct
up by the
evidence, and
Commission
not all these
itself
alternative sources of
expressly
evidence
qualifies
that the
itself
Commission may
by
rely
saying,
upon. I don't offer an
You've
opinion
already heard
on
me
the underlying
on the
medical
issue of
assessment
the electronic
made by
data
that
cannot
clinician.
answer the medical
So,
question. I've made
insofar
that point
as
a few
the
times, I
clash
don't
of
think I'm gonna
evidence
go
and the
there,
weight to be attached to
unless
the
the
evidence
Commission
is
wants me
concerned
to.
in the exercise of your
You've got that
discretion
in
as to
front of you.
whether
All I
a
would say,
postponement should be
and,
granted.
having
I come
read
back to the point that
the
the stronger
papers this
evidence
morning
is
again,
Mr. Karim's
as well as the
clinician's
correspondence,
direct evidence, and
you
not
also
all these
know that
alternative
there's
sources
a-
of evidence
that
I'm
the
gonna
Commission
use the
may
word
rely
challenge,
upon.
but I'm going to say it's inverted
You've already
commas.
heard me
There's
on
a
the
challenge
issue of
to
the
some of the
electronic
evidence
data
in front
cannot
of you,
answer the medical question.
how it was
I've made that point a
obtained,
few
but
times.
more
I don't
about
think I'm
more
gonna
than
go
just
there,
simply how it was
unless the
obtained,
Commission
whether
wants me
it's
to.
reliable because of
You've got
identified
that in front of you.
instances
All
of
I would
errors
say,
in that
and,
evidence.
having read
I don't think that you necessarily
papers
have
this
to make a
morning again,
ruling or
as well as the
determination on that
correspondence,
today. It's
you
simply
also
to
know
say
that there's
that in the assessment
I'm
of
gonna use
the
the word
evidence
challenge,
is
but
concerned,
I'm
you've
gonna
got
say
questions
inverted
about at
commas.
least reliability.
There's a challenge
and
to
some
the
of the
extent
evidence
that
in
any
weight
weight
is
is
going to be placed on
how
that.
it
You
was
should place
obtained,
less weight
but
on that.
more about
then
more
you
than
should
just the
simply
direct
how it was
medical
obtained,
evidence
whether
in front
it's
of you.
reliable because of identified
Could I then
instances
just make
of errors
progress
in
in
that
the 3
evidence.
minutes I have available?
I don't think that you
I think we've
necessarily
already
have to make a
foreshadowed
ruling
the
or
debate about
determination
my
on
sixth
that
point,
today, which
It's
is about the
simply to
14th
say
of August
that
versus some
in the
open-ended
assessment of
date,
the evidence is
concerned. You've got
the
questions
Commission
about
had right
at
up
least
front
reliability.
I said
that that would be a
and
judgment
to the
made
extent then any
by the
weight is
Commission
going
as
to
to
be
placed
how
on
it
that. You
fixes
should
it or
place
doesn't
less
fix
weight
it,
on that, having
then you
regard to the
should the
medical
direct
evidence in
medical
front of you.
evidence
I'm not
in
going
front of
to
deal with that
could I
further.
then just make
May I just say
progress
then on
in
this
the 3
issue
minutes
of
I have
the,
available?
I think we've
Already foreshadowed the debate about my sixth
the
point,
issue of,
which is
the
about the 14th of
independent
August
assessment. I
versus
think
some
we've debated
open-ended
that
date.
extensively already.
It turns on the
Commission had right up
characterization
front,
on whether
I
it's
said that
voluntary or
would be a
not judgment
judgment
made
made
by
by
the
the
also
Commission
turns
as
on
to
whether
how
it's
it fixes it or
facilitated
doesn't
or not
fix it,
facilitated, having regard to the medical evidence in front of you.
and there's
I'm not going to,
consensus between
deal
Mr.
with that
Karim's
further.
treating doctor.
May I just say that
If
if
you
you read
read
paragraphs
paragraphs
90 to 94 of the paginated pleadings, I don't need you to go there, I'll just
on the
give you a
issue
note.
of the independent
Paragraphs
assessment,
90
I
to
think
94
we've debated
at
that
record
extensively
pages
already.
53 to 54.
It turns on the characterization
And this is also
of
the
whether it's
sequence
voluntary or
that
not
the
voluntary.
Commission's
And
own
it also turns on
whether
whether
it's
it's
facilitated
facilitated
or
or
not
not. And if you look at
facilitated.
paragraphs 18
to 19
and there's consensus
I think I've
between
given you that
Mr.
already.
Karim's treating
You'll see
doctor,
that there's a synergy
if you
between
read
them.
we will need one
So,
up.
so if any direction is made regarding Mr. Karim and any voluntary medical examination, we would ask that the chair takes into consideration the involvement of Mr. Karim's treating clinician. We also know that there's a threat of a referral for prosecution if Mr. Karim does not appear again, whether advised or not advised, to not appear based on his medical condition. All I'll say in that regard is if the commission feels, and when I say commission, I mean the evidence leaders through the secretary, or is it through the chairperson through the secretary, feels that an offense has been committed and that a referral for prosecution must be made, then the evidence leaders must do what they deem appropriate, and Mr. Karim will also do what he deems appropriate, including leading evidence, whether at a pre-prosecution decision stage in front of the NDPP or at a post-prosecution decision stage in court that he was medically and legally advised throughout, and that any prosecution will fail because there's an absence of willfulness, and that will be demonstrated on the evidence. But I don't think you have to worry about that so much. That's out of your hands once any such recommendation would be made. I'd also just point out, and I'm trying to sweep now in the 15 seconds I have left, I just want to point out 3 interrelated propositions, if I may. The first one is that you will know on the last occasion, not when my learned friend Ms. Hassam was here, but when my learned friend Mr. Chaskelson, who's not in his usual place today, was here, there was some debate between whether or not, if Mr. Karim doesn't appear in front of the Commission again, and Chair, this takes us back to our recollections may vary, because what I seem to remember is after you and I had that discussion about voluntary versus compelled, the discussion then moved to what are the inferences that can be drawn in the ordinary course about the so-called unanswered questions that Mr. Karim would not have answered by the end of this process if he never comes to the Commission again. I see the Chair is nodding, so at least I'm remembering that correctly, I think. But the point that I would make is at that time, and in its letter of the 24th of June, the Commission's evidence leaders were emphatic that if Mr. Karim doesn't come again, they're not going to entertain this business about a postponement or no postponement. They were going to ask the Commission to make conclusions, or even on an inferential basis, on the basis of those unanswered pieces of evidence, and if necessary, to make a recommendation. And all I would point out is that the sudden change in now seeking to compel Mr. Karim here seems to stand at odds with that, and the Commission must take whatever decision it wants to take regarding how it deals with Mr. Karim in circumstances where it has direct evidence in front of it explaining his non-attendance, as it were. The last 2 points I'll make, and it is really the last 2 points, I'm 1 minute over time, is that there are many new allegations that are introduced in the answering affidavit of the Commission. And you know that on the papers, and particularly in the correspondence, I'm going to use my favorite A word again, there's a statement made about trial ambush in the sense that not the entire case is sought to be answered is made clearly for Mr. Karim and his legal team and the deponents on his behalf to answer, and then they are ambushed after the fact to say that you've failed to answer this or that you're being deliberately misleading or inaccurate, whereas there are innocent explanations for these things. And if the Commission just showed its hand earlier, then it could have been dealt with earlier, and we wouldn't need to go 17 rounds in exchanging affidavits and supplementary affidavits because we'd know the case to meet. Chair, you'd remember you said to Mr. Chaskelson the last time, put it on a piece of paper, those questions you want answered, that was supplemented by Commissioner Khumalo. It's the same complaint, with all due respect, that we shouldn't be drip-fed information. We should know what the Commission has in mind so we can be helpful to the Commission in answering whatever we can, whenever we can. And lastly, may I just say that on the issue of the relief, the terms of the relief are obviously to be finalized, but on the underlying request for the postponement to a specified date or to some other date is ultimately unopposed. And that's Mr. Karim's submissions in 1 hour and a bit. Thank you, Chair. 1 hour and 3 minutes.
Oh, thank you very much, Mr. Premier. Let me just take you to page 24.
I'm there.
Yes. Please read paragraph 67.2. And after that, 67.3.
Yes.
And also go to 71. Read 71. I'm not reading these because...
I understand why.
Chair,
Yes.
sorry to interrupt, but what page are you referring to?
25.
I said 24 initially, and then it's 24, page 24 was the first reference.
67.2
Paragraph
and
67.2. And then 67.3. And then I was moving on to the next page, 25, paragraph 71. Now, I want to ask a question that relates to the information that has been asked for repeatedly, which is the name or names of the auditors / accountants of Mr. Karim's companies. That's number one. Number two, the financial statements of those companies. That information was asked for a long time ago, I think in March already. I think initially when Mr. Karim was testifying here on the 8th and 9th of March, I think, and he promised or undertook to furnish that information. In fact, I think in respect of the auditors, he furnished a name of an entity that eventually denied that it was auditing any of his companies. But subsequent to that, that is the oral undertaking in open session, there has been engagement on that issue, and Mr. Shaskalsin has repeatedly made the point about this information continuing to be outstanding and not being furnished. So it's something that's been out there in all of our minds. Now, I refer you to these 3 paragraphs to make the point that, one, the person mentioned in 67.2 is Mr. Karim's PA. And she's even described as his quote-unquote virtual PA. Quite importantly, here's what is said about her. It is said that when Mr. Karim's bank account or bank accounts, I'm not sure whether it was more than one, was aware in the process of being closed by F&B, this virtual PA played a very crucial role in that process. So it seems to me that this is someone who is closely involved in Mr. Karim's affairs. Now, the other person mentioned in the other paragraphs is someone very close to Mr. Hassim and someone who has in his...
Mr. Karim. Not Mr. Hassim.
Oh, I'm so sorry. I'm sorry, Mr. Hassim. And it's someone very close to Mr. Karim and someone who has been appointed to run Mr. Karim's businesses in his absence. Now, if you look at, which paragraph is it now? Let me see. Yeah, I think it's 20, so 20, content of 25 about, oh gosh. I've lost my place now, but you will all know what I'm referring to. I just have page 25 now, I would imagine. I doubt that it's there, but maybe it is. But the point is this. The deponent to Mr. Karim's affidavit, the founding affidavit says, I do not know the auditors of Mr. Karim's affidavits. I think I can mention that it's his wife. What the ruling says should not be mentioned are the names, I think, and other identifying features.
He also has two, so
One of the wives is the deponent. Thank you. So that's the wife. She says, I do not know. And she says, nobody else knows. So this means the virtual PA, who I assume that as a PA, she must be working very closely with Mr. Karim. And the fact that she even assisted very closely when the bank account or bank accounts were being closed shows the proximity. I do not see the basis on which Mr. Karim, with regard to who the auditors are, would have been cagey about that information. Not to the PA. I do not see how he would have been. Also, I may not be able, because I do not know the historical involvement of the person now running the businesses prior to him doing so after appointment. I do not know his historical involvement in the companies. But point is, once involved, what would be so difficult in him getting information with regard to these two issues, who the accountants are, and even getting copies of the financial statements? Just what would the difficulty be? Also, this person who's now running the businesses is not the only person. There are other people who have been in place working in those companies. That information cannot reside in Mr. Karim's head only. I find that very, very difficult to understand. In fact, I want to say this or suggest this to you, Mr. Premhead. You probably are aware of the Gauteng High Court judgment in the case of truth verification. If I'm not mistaken, I think it was written by an EL of AJ, not the old freaky EL of JP. And the principle enunciated in that case was later made or adopted by the Supreme Court of Appeal. But the point is this, and perhaps let me clarify up front, that that principle relates to respondents who make fanciful or patently false statements on affidavit. And that authority, jurisprudential authority, exists because on paper, where you do not test the testimony of witnesses in a witness box, it's very difficult for courts to say that person is not telling the truth. But the usefulness of this authority is this. It says, if what a witness says is either fanciful or patently false, it should be rejected out of hand and on paper without the need for oral testimony. So even if, as I say, this principle has been used in respect of respondents, I do not see why it cannot apply to applicants as well. Where am I going with this? I feel, as I sit here, subject to what you say, that the idea that nobody within these companies, in particular the person now running the businesses, and this PA, nobody can furnish this information. Nobody knows anything about this information. Subject to what you say, to my mind, this appears to be patently false. Your comment?
Natal Scrap Metal and Oxford University Press also endorsed that proposition.
Yes.
On consideration of the Plascon-Evans test. So I don't know if those were the
Yes,
SCA authorities you had in
that
mind.
would have been a movement or a development on the
Indeed.
Plascon Evans.
No, but I know the proposition that you're making.
Yes.
Can I direct your attention to paginated page 74, particularly paragraph 40.1, as it relates to I'm using this word in inverted commas, an inference that is perhaps being made about the role and level and intensity of the EA or PA or whatever she's called, and the extent to which they might have business knowledge. And the starting point was, and Chair quoted it, was her involvement when the banking accounts were being closed and so on. With all due respect, I would suggest that 40.1 attenuates that, because it speaks to the very limited and I'm going to say rubber stamp, and you'll understand why when you see that paragraph, that rubber stamp manner in which she acted. So I'm not sure, with all due respect, in terms of what is in front of you on the evidence, that she does as intensive a role as perhaps Chair was suggesting. Obviously, Chair will draw his own conclusions.
Open quote, managed the replacement, close quote.
Yes,
that's an advised or conscious choice of word.
Yes, and then look at line
managed.
But look at line 3, how she managed it and that process. She had access to and used an electronic signature during that process. So the point is that her involvement, and I'm speaking carefully because I'm not giving evidence.
I'm not sure that the third line suggests that all that she did was to sign electronically. I'm not sure about that. I believe in context that that's mentioned as part of the things that she did. She signed. It doesn't suggest on my reading that all that she ever did was merely to sign electronically. That's not how I read this. She managed. Otherwise, manage would be meaningless if all that she did was just to sign.
I accept what you say, but I would also then ask you to go back to 67.2 on page 24, because if you look at who she works for, it's not Mr. Karim himself, it's the wife. That's stated in that paragraph in the first sentence. And then you'll see what she does is, all she does is she screens my husband's calls and emails, liaises with the banks, including in relation to the closure and the replacement accounts, facilitates payment for staff.
Sorry, page?
24?
24.
The paragraph 67.2 that you took me to, Chair, at the beginning.
67.2.
Yes, point two. So I was just saying that the first sentence contextualizes who she's actually working for. It's the wife, not Mr. Karim per se. And then in the second sentence, you'll see what her activities involve. And her activities are described as screening husband's calls and emails, liaises with banks, including in relation to the account, and we've gone to that page already, facilitates payment of staff, and directs matters requiring attention to the appropriate person. So I accept Chair reads that in a different way to I do, because Chair says that's indicative of a more central role that perhaps suggests she could provide these answers or whatever the case is.
Yes,
I don't read it in the same way.
I do not see after, towards the end of the paragraph, what you've just read, I do not see how her role can be diminished, not with all of the things that are itemized there as her duties. I do not see how her role can be diminished.
I accept what Chair puts to be, I'd say it can be diminished because it's not a decision maker qua decision maker. It's clearly that she plays a supportive role. And so she doesn't have this as expansive ability as Chair is perhaps suggesting to do the kinds of things that Chair is speaking about. So that's the first thing I would say in respect to that individual. The other page I would ask Chair to look at, and I had it a second ago if you'll bear with me, is paginated page 351. And all I point out is paragraphs 51.1 and 51.2, particularly the last sentence on 51.2 on paginated page 351, because that in part speaks to Mr. Karim and the ability to obtain that information and why even what has transpired before transpired in the way that it did. Insofar as the other individual which Chair mentioned, which is back at page 24, paragraph 67.3, if I'm not mistaken.
I think, was it not also 71? I've closed
Yes, no, 71 as well. That was on page, that was on page 25.
I meant paragraph, not page. I meant paragraph 71.
Paragraph 71, page 25, which speaks to the same individual that is mentioned in 67.3.
Okay, yeah.
Yes. Again, all I would say regarding this expansive role that he's playing or he's not playing is look at the fifth line in that paragraph 67.3, starting with he does not make. And I would say that that sentence is a direct answer to the Chair regarding what he knows or doesn't know or couldn't know. In particular that...
Mr. Premier, providing information has nothing to do with making strategic decisions and new business decisions. It's historical information.
Yes, indeed, which is why the sentence I was going to direct you to, Commissioner Khumalo, reads in terms, given his age, he does not possess the institutional knowledge of the businesses that resides with my husband. So even if you're interpreting that first sentence against me about providing information not being strategic decision-making, which I can accept, the second sentence in particular speaks in terms to his ability to provide the information or otherwise. If you reject the explanation on paper, that's what you'll do, but that's the evidence you have in front of you. So also insofar as the same individual is named at paragraph 71, page 25 is concerned, you have to read those two things consistently with all due respect, which says that the individual concerned is doing nothing other than acting in a holding pattern or in a holding capacity, but doesn't have the institutional knowledge going backwards and also doesn't have the strategic insight and knowledge going forwards. But I accept, Commissioner Khumalo, that might be an unsatisfactory explanation.
You have not answered the second part of my issue, which was, how can it be that within these institutions, all of them, there is not a single person who knows something about the accountants or auditors? How can that be? How can that be? How is it that this information resides only in Mr. Karim's head?
I want to choose my words carefully because I'm not going to give evidence as to why that is or isn't the case. But I think it was Commissioner Baloy, you'll forgive me, on a previous occasion when Mr. Karim was testifying, there was a debate between Commissioner Baloy and Mr. Karim about how particular decisions are made or not made and are there proper books of account, and what's the regularity of what's going on inside this business from a corporate perspective. And Mr. Karim at that time did not say much other than to say how it appears in front of you is what it is. And without putting words in his mouth, all I will say is that businesses operate how businesses operate. They sometimes operate imperfectly. They sometimes operate less elegantly than they should operate. Whatever inference you want to draw from that, you will obviously draw, but the fact that it's not so elegant and bookkeeping or company board resolutions are not maintained in the way that the Companies Act wants them to be maintained is the very basis that most of us have a job as lawyers, because these things happen in the real world in the way that they happen. So I can't answer with a positive version as to what the chair puts to me, which is how is it that it can only be one or should there be others? I have no instructions in that regard, but having regard to what has previously occurred, where Mr. Karim was put under some pressure, and I say that respectfully, put under some pressure to account for his business operations, which appeared to be less than perfect, he himself couldn't address that in any great detail other than to say that the businesses were and are what they are. And that's as far as I can take it, Chair. I mean, yeah, I'll leave it there.
Can you please assist me? I wrote only paragraph numbers of the doctor's report. Where does it start? Please assist me. I want to take you somewhere there.
Sorry, Chair, can I ask for a clarity? Is it one of the doctor's reports or the affidavits?
The affidavit, affidavit. The very first one, not the supplementary.
Paginated page 30, Chair.
30. Thank you, Mr. Premier. Oh gosh, how could I not have, because I can't read this again, nor can I describe it because it will
Paragraph number,
go to
Chair.
the wrong terrain. Let me just see.
Oh.
Okay. Oh gosh, I'm sorry, I did not underline this. But I seriously want to engage you on this. I can't vocalize the point, otherwise it will, can we take a 2-3 minute adjournment? Please, I want to vocalize this outside.
Okay.
Let's adjourn. think an explanation is owed to the public. This was not turning what I ruled would be an open session into an in-camera session. No. The reason for going out is that everybody will recall that earlier I asked on a totally different point or issue. I asked Mr. Premhead to read certain paragraphs for himself, and then I put questions to him. The reason for doing so was to avoid divulging the sort of information that I said, or in my ruling, should not be divulged. So that's why those paragraphs were not read publicly. Now, this time around, I wanted to do the same thing. That is, refer Mr. Premhead to a paragraph for him to read for himself. The reasons were exactly the same. The problem this time around was that I did not find my correct note which directed me to the paragraph, and I was only able to find it once we were outside. So Mr. Premhead, I believe, has now already read the paragraphs. Now, here's my question, Mr. Premhead, and it relates to both paragraphs. Why is it that if Mr. Karim could do what is stated in those paragraphs, why is it that he cannot likewise do what he has been required to do, which is to furnish the information that has been requested repeatedly?
Paginated page 45, paragraph 53.1. I can't read it for obvious reasons, but I'll ask that.
Oh, sorry. For the record, let me just mention, because I did refer you to paragraphs by paragraph number.
Yes.
This time around, for the question I've just asked, the relevant paragraphs are paragraph 25 and 66.
Chair, I think it was 69 on page 25, and then, oh, is it not?
Page 49, paragraph 66,
Yes.
and page 25, paragraph 69.
Yes, I did it, yes.
Yeah.
On
Thank you.
paragraph 25.
Thank you.
Yes.
Okay.
So that's the first answer, is the one that I gave, is paginated page 45, paragraph 53.1, which adds some color perhaps as to why something that is described as a simple issue or decision or divulgence is not as simple as it is. I would particularly ask the commissioners to look at the sentence beginning second comma on line 3 of that paragraph. That's the first part of the answer. The second part of the answer is paginated page 48.
Sorry, but what do you make of the word interactions there? Would that be the sort of interaction that the doctor is talking about here?
Yes, that's my submission.
Okay. All right. Please continue.
And on that page, if you look at the sentence beginning third, which is 4 lines from the bottom, that adds further color and context. The second answer I will give is paginated page 48, paragraph 65. It's a long paragraph, but the part of it I would want to emphasize is the last sentence starting at the top of page 49, which is just above the paragraph the chair referred me to, which is 66 on page 49. Starting rather, and it's 3 lines. So why I point your attention to those paragraphs is for 2 reasons. The first one is you've heard me already. I'm not going to repeat myself, but Chair views those 2 other individuals who I'm not going to name as having a greater role perhaps in the running of the businesses. I pointed out the fact that according to what the affidavits say, that is perhaps not correct, but obviously Chair will make his own assessment. And then the second reason I'm pointing you to these particular paragraphs is to say that even if it's as simple, in inverted commas, for an instruction to be given by Mr. Karim to those individuals, those 2 paragraphs need to be borne in mind in respect of the instruction and the ability to give that instruction.
How I read this is this. What comes before 66, which is the paragraph I referred you to, what comes before 66 deals with why Mr. Karim would ordinarily not be in a position to be of assistance. But what is in 66 qualifies all of that. It even uses by contrast. So it's contrasting what's stated in 66. So you can't read what comes before the contrast in isolation, as it were.
Yes, but with all due respect, I think if you look at 67, for example, the next paragraph down from 66, and if you look from the 4th last line from the bottom, regarding what the doctor says is his clinical opinion, then what Chair says to me is the qualification in 66 in respect of what comes above in respect of 65, which is the paragraph I relied on, is itself further qualified regarding Mr. Karim and his ability, and what the inherent risk is throughout the proceedings. May I
ask this, and I hope this will be the last question I'm going to ask. Why is it that Mr. Karim's founding affidavit, which is followed by a supplementary affidavit, does not deal with No, I will drop that.
Because it deals with that has to go to who the deponent is.
Yeah,
That's my answer.
I will drop that question.
But can I just say that my third answer to you, Chair, and this speaks to the context of the instructions that I said I would undertake to give. I'm reading from my phone and I'm paraphrasing, so this can be dealt with formally after the fact, if needs to be, but I am told as follows. Contact was made by my attorney with the deponent of the founding affidavit, who contacted the treating doctor whilst he was consulting with Mr. Karim. The purpose of that was to take an instruction on the issue that Chair and I were debating earlier. And we are advised that Mr. Karim has suffered another medical incident and that no instructions can be obtained by him in respect of what Chair has put to me. and this is in the context of this facilitative process that we've been talking about. I'm also told that the clinician has expressed his frustration to Mr. Karim's attorneys because, in his view, his client's position is deteriorating as a result of the pressure being put on him by his attorneys in respect of commission and commission business. And so what that relates to is exactly what I pointed out to you in those paragraphs I flagged, and that's the situation we find ourselves in.
I've remembered the question I wanted to ask. The mistake I made was to want to relate it to Mr. Karim's wife, the deponent, to the affidavit. What I meant to do was to say, why is it that Mr. Karim's doctor does not deal specifically with this issue? You will have noticed that...
About the, sorry, Chair, specifically the issue, the accountant auditor issue.
Yes, why I raise it is because that's quite pertinent, and the doctor has dealt quite extensively with some matters of detail, even dealing with issues relating to his whereabouts. And if I read his reports correctly, I do not recall that he deals with this aspect at all, and to explain why Mr. Karim cannot furnish the required information. I might be wrong. Maybe it's somewhere there. That is somewhere in the reports.
Well, and I think this is the best answer I can give you. If you look at paragraph 53 on paginated page 44, that will tell you about the doctor's intervention, so to speak, in Mr. Karim's business affairs, or what he did in respect of Mr. Karim's business affairs. A similar point is made.
But that's about him not running his businesses, which explains why someone else has been appointed.
Correct.
It doesn't answer the one issue. Such and such information is required by the commission. So 53 does not answer that.
No, correct.
Yes.
But I was...
That's not running his business.
No, correct. The point that I was going to make is 53 and 55 on page 45 give you the context of how the doctor enters the equation, for lack of a better phrase, which is to give the family certain advice regarding what happens to the business. The doctor himself never says that he gets involved in the business per se. He has a facilitative role where it's appropriate to play a facilitative role. And there are instances where sometimes that facilitative role is more restrictive, not less restrictive. And the answer for that is that paragraph I gave you on that same page, paragraph 53.1, page 45. So the reason it's the best answer I can give you is because the doctor himself says that whatever matter has to go to Mr. Karim through the doctor is not just simply relaying a telephone message or relaying a question, but that the doctor himself has to make a clinical assessment at that moment in time, for example, about whether the question, if put, would cause a deterioration or not, or whether, even if the question is put, the answer given is a good answer or a bad answer for whatever clinical views the doctor themselves may have. So I can't speak to why he did not deal with that specific issue isolated as a line item, but you've also heard me that when instructions, as a real-life example of what has happened when instructions were sought, but that adds context as to why he might not have dealt with it. That's as far as I can take it.
Thank you. That's my last question. Thank you, Mr. Premhid. Yes, Ms.
Thank you, Chair. Is it my turn now?
Apologies to Ms. Hassam.
There's
No,
1 hour and 51 minutes.
No. It was, what, a couple of minutes only. So it was my, it was by 15 minutes. Ms. Hasim?
Chair, I will be extremely reasonable, and I won't ask for an equivalent amount of time as Mr.
Which
Clement.
will end at what, 9 minutes to?
It's 9 minutes to 4 now.
Yeah, so 9 minutes to 5. Please, yes.
So, Chair, can I do this? Can I just address the last topic you were debating with my learned friend and just close that off? Because I was going to deal with it in any event in the course of my address. But since you are on it.
There were the issues, or we'll deal with that at the end. Maybe do that at the end. The issues about possible rulings. The two issues Mr. Premier raised right at the beginning.
No, I'm talking about what you were just debating now.
I'm saying I said I would raise those issues with you when you begin your argument.
Yes.
Should I perhaps address those right at the end?
Those were the issue of the footage.
Yes.
And the redaction of the record
and
through
the redaction of the record.
Yes. Oh.
Can I just deal with this topic that you were debating, and then I'll begin with those.
All right.
Turn to those rather. So just on this, because it's fresh in your mind, because you've just been having the debate with my learned friend. The few points I wish to make about it, because I must admit that I find it quite an extraordinary claim that has been continually held since the time the Commission first asked for those documents. Well, first of all, one is not even a document, it's just the name of the auditor. That's all. It's a very simple request. Why I say that I find it extraordinary is because that request was made as far back as when Mr. Karim appeared in this commission. That was on 9 and 10 March. On 10 March, it was itemized what the specific, it would form part of a list of requests that we had. We itemized the requests. In fact, I'm sure if we go back to the transcript of the 10th of March, somewhere towards the end of the transcript, it will be there. So this request is months old. That's the first thing I'd like to say. The second thing is that if we look at paragraph 66 on page 23, the paragraph reads the first sentence. In fact, let me just read the paragraph. Before 13 April 2026, before 13 April 2026, my husband was fully involved in his businesses. And then she explains now what that involvement entailed. But there's no explanation to us as the evidence leaders or to the questions that have been posed by the commissioners, why these documents and this information could not have been provided between 10 March and 13 April. There's just no answer to that. Instead, what my learned friend does is he goes to the various paragraphs that have been debated just now. For example, on page 74 of the paginated bundle, where the chair, I think it was the chair who directed my learned friend to paragraph 40.1 and the person and the PA and the issue of the FNB accounts. And my learned friend tries to say, well, actually it was just a rubber stamping exercise because all she did was place an electronic signature. That's not borne out by the text in that paragraph. That paragraph doesn't say that's all she did. It says that's one of the things she did, is that she appended an electronic signature. But that's not all she did. That's not what that paragraph says. And what my learned friend is doing is with respect, taking liberties with the construction of these various paragraphs, and he's straining to defend an indefensible proposition that there is nobody in the company or in any of these companies which do business in the amount of hundreds of millions of rands who can say who the auditor is or where to find the financial statements. And I'll just make one last point, because I mustn't, for the sake of completeness, on page 25 on the debate in paragraph 71, that his son has stood in for him. What that paragraph says is that he assumed overall responsibility for overseeing the businesses and ensuring that their operations continue in his absence. He is a central point of contact, attends to matters requiring attention, oversees the payment of expenses and the continued performance of existing obligations. And then read that with 67.3, which my learned friend went to explain, well, that the role of the son is that he doesn't make strategic decisions. Well, yes, that's true. 67.3 says he does not make strategic decisions or decisions concerning new business. So we're not making any queries in relation to new business. We're making a query that falls smack bang in the middle of what Mr. Karim's son is responsible for, as articulated in paragraph 71. So those are our submissions on that particular topic. Now, I don't need to go there later on in my address. So, Chair, on the question of the redactions, we have no objection to that. On the question of the CCTV footage, what I'd like to say is that, and what I would like to make clear at the outset, is that the point of the evidence on Mr. Karim's movements is not put up to try to disprove a psychiatric diagnosis. It's not put up to...
Chair, I must just interject.
I apologize, it slipped out.
This is now the second incident where slippage is occurring. It happened the last time as well. And I would ask through you, Chair, that the evidence leaders please pay extra special, careful attention to the choice of words, because of the exact reason we asked for an in-camera hearing. This is now the second occasion it's happened.
Chair, may I apologize? It's in the course of speaking off the cuff.
It should not happen. It simply should not. And as Mr. Premit says, this happened at the last hearing. Mr. Shaskalson did exactly the same thing.
I'm aware.
It should not happen.
My profound apologies. It was entirely unintentional.
Chair, may I just say, and I'm sorry to do this whilst my learned friend is now on her feet, but the fact that I've had to object has itself now drawn attention to something potentially. And so my client's rights are now really being prejudiced because, and I make no statement about Ms. Hassam, who is a consummate professional, and I fully accept it might have been an accidental slip. But even the fact that I've had to record the objection now elevates the issue and creates the very damage that we've tried to protect my client from. And I'm in an invidious position where I am where I am. And so I would ask, Chair, not that you can control the media or anybody else, but just to remind people about their responsibilities in what they say publicly regarding the impact that can have on the dignity and privacy rights of someone who's made an express claim for confidentiality to avoid this exact situation. And I'm sorry to interject my learned friend while she's on her feet, but I have to now place this on record as a matter of principle that we're heading into dangerous territory.
Thank you, Mr. Prem. for now, let's leave it at the point that I have made, the admonition that I have made, and let Ms. Hassim continue.
Thank you, Chair, and I do reiterate my apologies. It was entirely unintentional. It's difficult to take out from one's head all of the information we've been looking at and reading and dealing with over the last few days. What I wanted to say was that the point of putting up the evidence on the movements is not to disprove any diagnosis, not to use it to challenge the clinical findings of a treating doctor. But it is important because what it does is it bears directly on Mr. Karim's demonstrated ability, his day-to-day functioning capacity. That's what the movements go to. And it also goes to something else, which is, and I'll come to it later, that it's about the reliability and completeness of the information that was before the treating doctor at the time when he deposed to the affidavits that we now have in this application. So that's the relevance of the movements.
Are you saying, because the issue as I understand now is about flighting or not flighting?
That's right. So,
are you saying you require flighting for purposes of what you've just explained?
No, Chair, it was just a preliminary point to explain why we go here at all, that it's not simply for the purpose of showing that Mr. Karim was in fact in Durbanville on the 14th of July. It's not merely for that fact. It's more than that. But I can continue to make my submissions to the second point that I'm raising about day-to-day functioning without flighting the footage. And I will make that.
Yes, that's exactly how I understand it. I do not see what stands in your way to make those submissions without flighting. I simply do not understand. But as you say, you've just said now, you are able to make those submissions. So
I'm perfectly,
yes.
I don't need to rely on the footage in order to make those submissions.
Yeah.
And
because there's the admission by Mr. Karim through the deponent, his wife, that he was indeed in Durbanville and at this particular shopping center, that he went to Woolworths and this other place. I can't pronounce that name starting with a K, with many vowels in it.
Kauai. So I'm going to talk about that evidence, but I don't need to flight the actual CCTV.
Thank you. So that takes care of Mr. Prem's, one of Mr. Prem's 2 points.
I think both, because we also have no objection to the redactions.
All right, thank you, thank you. There was, what was the third thing? Oh yeah, there was the issue about the geolocations.
Oh yes. I think in the context of the sensitivity of what we're dealing with, and perhaps, Chair, I should just refer to the ruling that you made yesterday, because that's the constraints that are governing my ability to make submissions to you candidly. So the ruling, Chair, would you indulge me reading out paragraph 2?
Please.
Because then it might help the public also understand why we're talking in this coded way. So paragraph 2.1 says, the legal representatives of Mr. Karim and the evidence leaders may not, during the hearing of the postponement application, mention Mr. Karim's medical condition, the nature of the treatment he is receiving, the identity and nature of practice of the health professionals attending to Mr. Karim in respect of the medical condition, and the medical facility where he is admitted. 2.2, publication or dissemination in any format of the information referred to in paragraph 2.1 is prohibited. 2.3, the legal representatives of Mr. Karim and the evidence leaders may not, during the hearing of the postponement application, mention the names and residential and business addresses of Mr. Karim's family members. That's the relevant part of the ruling. So, Chair, I am not going to flight the geolocation spreadsheets. They are in our papers. Everyone on Mr. Karim's legal team side has seen it. The commissions have it. I don't think it's necessary to do that. I think if we were to do that, we would run into trouble. It's not possible to redact every single entry, and some entries are relevant to where perhaps Mr. Karim's family members are. So we won't flight that either. So, Chair, and then consistent with this ruling, what I propose to do is, and I'm going to try to stick to a script a little bit, because when we are in open debate, then mistakes happen. With your approval, I intend to refer to the two doctors as Dr. Initial and Dr. Initial, to distinguish between the two. Would that be acceptable to the chair?
Why not use the first doctor and second doctor?
Okay. Okay.
And you can simply say, for example, the first doctor being the one with the substantial reports that we have in front of us. And I'm not even sure who the second doctor is.
Could I say our doctor, our expert, and their doctor?
Good.
Something like that. Okay.
Thank you.
All right, so I'll proceed in that fashion then. I think the next and the point, and it was the first point that was raised, substantive point that was raised by a learned friend, was that somehow we're not really opposing the evidence leaders, the postponement application, but and that we've conceded something. I'm not sure how that arises. The heart of our opposition as the evidence leaders is that the Commission should not grant a postponement without requiring an independent medical examination. That is the heart of the opposition by the evidence leaders to a postponement. And the reason for that is because we've had a history of postponements where the length of time that we are told that Mr. Karim will be incapacitated has varied and grown each time. So in the beginning, it was a few weeks, then it was 8 to 12 weeks, then it was 6 months in the latest round of affidavits. So it's very important to the evidence leaders that we have a fixed date for the postponement, number one, and number two, that postponement is conditioned on an independent medical examination. I'd remind the commissioners that this is the 5th postponement that Mr. Karim seeks, and we've set out the history of the delay at paragraphs 7 to 24 of our written submissions. I'm just going to turn to those submissions. I don't need to go through the details. All I'll point out is that what one sees when one looks through the history of that correspondence and the postponements and the delays is that Mr. Karim's attorneys seem to believe that a postponement is available for the asking. One example of that is at page 67 of the correspondence bundle. If we could just look at page 67 of the correspondence bundle. And if you look at paragraph 9, this is a letter that was dated 13 May 2026 from Mr. Karim's attorneys. If you look at paragraph 9, it was again in an attempt to get a postponement of the next hearing. And all we are told in paragraph 9 is we confirm that that we have now received the further medical report. This report is highly personal. Suffice to state that our client has been laid off for at least 8 to 12 weeks, and that was all. No medical certificate or report or note or anything accompanied this. It required requests from the attorneys for the Commission to obtain the necessary medical report to underpin the postponement request that was made. So that's the history that we're dealing with here, which is why the evidence leaders feel so strongly that getting finality and a specific date is so critical. We then come to the latest. I'd rather go to the most recent history on the postponements. The last postponement was to 15 July. Up until that point, all of the postponements were granted, were permitted, on the understanding by the Commission and the evidence leaders that Mr. Karim was hospitalized and that his movement was restricted. That's what we were led to believe. It was only when there were the 2 whistleblower reports on the 14th of July that the issue of Mr. Karim's movements were put into question. The evidence leaders then obtained the CCTV footage to corroborate what we'd been told by the evidence, by the whistleblowers. Mr. Karim was then afforded the opportunity to bring a substantive application for the postponement. And in that application, an opportunity was provided to address the latest information regarding Mr. Karim's movements around the Cape. And this is addressed in 2 affidavits. The one, as we've already been talking about, is by his second wife, and the second affidavit is by his doctor. What we were told in those affidavits is important. Their accounts, and I'm not going to go into the detail, it's summarized at paragraphs 39 to 44 of Ms. Berger's answering affidavit. What we saw there was a particular picture that was painted by the 2 deponents, and particularly by Mr. Karim's doctor. That picture was one of restrictions on Mr. Karim's movements and interactions. We were informed that any leave from the hospital would be authorized for specific purposes, that there were passes that were subject to strict conditions, including searches, etc., including on the return of the 14 July excursion, which was said to have been a 4-hour chaperoned excursion that took place between 1:30 in the afternoon and 5 p.m. in the afternoon. That was the account that was provided by their doctor. It was supported by Mr. Karim's wife. Now, it's important, commissioners, to go to those affidavits. So let's look first at what Mr. Karim's wife says, and that's at paragraph 60 of the founding affidavit. if I could ask the commissioners to read paragraph 60 and its sub-paragraphs, where the 14 July incident is explained. I'd like to place emphasis on 60.2, where it says, we departed the facility at 1:30. Then 60.3, and the description of the Kauai engagement. 60.4, and 60.6, specifically where it says we returned to the facility by approximately 5. And then there was a consultation that they both, I emphasize the word we in 60.6, attended. In paragraph 73 of the same affidavit, the deponent summarizes all travel since 13 April 2026. And I draw your attention to paragraph 74, where the deponent says, my husband undertook no other travel during this period and did not travel to Mahikeng or any other location in the Northwest. There's a second affidavit, which I'm going to come to, in which this is a different picture is painted. And what the deponent says later is that that trip to the Northwest took place during the week when Mr. Karim is with his first wife. And so, says the deponent, she did not know about the trip, and that's why she didn't say anything about it. What my submission on that is that that's implausible when we have regard to her own evidence that she communicates regularly with the first wife, and you'll see that at paragraph 15 of this affidavit, of the founding affidavit.
But what about the fact that she says this was the first wife's week, and that she might have missed this visit to Mafikeng or Mahikeng because of that fact?
Yes. I'm saying it's not plausible because they communicate regularly. She explains in paragraph 15 that they communicate, she and the first wife, including
Does that mean every and anything?
No.
Of necessity?
No, Chair. So let me then go to paragraph 15. It's because what they communicate about is Mr. Karim's well-being.
Yes, yes.
And his health.
Yes.
And updates on.
But as I understand it, it was Mr. Karim who wanted to go there to see.
Yes.
Was it his daughter? I think to see.
Yes. I have no objection.
His daughter.
Yes.
Now, so it wasn't as if I'll be with our husband in Mahikeng, but I'm concerned about his health because the travel might do this and that to him, in which event the first wife might have had to tell the second wife. Now, this is just a visit to the daughter, which was quite important to Mr. Karim, because as I understood it, he had not seen her for...
Chair, we don't even need to get into that. We don't take issue with his wanting to visit.
But my point is, with nothing that has been suggested about his health and him going there, I do not see why it would have been necessary for the first wife to tell the second wife about the Mahikeng
For this
visit.
reason. for this reason, Chair, because there was a medical incident.
Sorry?
There was a medical incident.
By the way, which resulted in his...
In the second wife, accompanying
in
Mr.
his
Karim.
return. In his
Correct.
return. Okay.
Correct.
No, I get it. I'd forgotten about the sudden need for him to return. Yeah.
That's right. And it was the deponent who took Mr. Karim to the doctor and accompanied him and was with him during the consultation. And so that's why I say.
So your point is it's unlikely that the second wife would have forgotten about this incident.
It was specific.
Yes.
I'll tell you why.
Yes,
Because it wasn't a broad question, tell us about the movements. It was a specific question was asked about movements to the northwest, because that was something that became contentious.
No, I get the point.
Then we have the doctor's version on the 14th July in his first affidavit. And we'll find that at paragraph 45, and I think it's page 43. 43, thank you. So in paragraph 45 is where the description of the 14th July incident is. And what's important here is the confirmation that it was 4 hours, that it was for the purpose of purchasing toiletries, over-the-counter flu medication. In 46, the doctor says, in terms, the facility's records reflect that he departed at approximately 1:30 and returned at approximately 5. He goes on to say he doesn't know anything further about the precise movements during the 4-hour period for which it was authorized. And then says, but in any event, these kind of excursions are not unusual. I'd also like to take the Commission to paragraph 39 of the affidavit of the doctor, because, and that's at page 41. Here too, the doctor says, in terms, I deal next with the facility's leave regime, because I understand that an impression may exist that the facility is a place a patient may enter and leave at will. That impression would be false. And then he explains there's only 1 or 2 ways that a person could leave on the pass of the treating doctor. Or the only other way is if the person discharges himself. What happened next was that the evidence leaders obtained geolocation data. That's the data of Mr. Karim's cell phone that tracks the movements of the phone. We know from the first, from the first deponent that Mr. Karim keeps his phone with him. We presented that information to Mr. Karim's legal representatives on the 17th of July. That then prompted 2 further affidavits. So, if I can just go to the first, it's the supporting founding affidavit. Sorry, it's not supporting, it's a supplementary founding. What we see now, what page is it on? It's page 58.
That's where it starts. You want to take us to which?
To the paragraph. I'll do that, Chair.
Oh, all right.
Just trying to find my own reference. Right, I've got it. It starts at paragraph 27. Page 67. And that's where the account is amended. It's confirmed in paragraph 27 that Mr. Karim was at a shopping center, that he was at Woolworths, that he was at, she says he then purchased a meal from Kwai, finished his meal at Kwai, and thereafter obtained flu medication. He was supervised throughout by his security detail.
And an important contrast here is that he did not buy a takeaway and go and eat in his car. He actually sat down, had a meal in Kwai, or whatever it's called.
Yes. Yes, at Kwai,
The owners will not be happy with me.
I think they'll be very happy with the free advertisement that they're getting. But so, Chair, the discrepancies are, that's the one. The second is that if you look at page 68, paragraph 28.3, I'm not going to, I can't read it out.
But is the second point you want to make the fact that this pass was not was it 4 hours, the shorter period mentioned? It was not for that, but
much longer period of time.
Basically, I may be exaggerating if I say close to the entire day.
It was
8 hours or upwards.
It was almost 12 hours.
12.
So, as confirmed by this deponent, who says when he arrived at where she was in the morning.
I'm doing that. That is going straight to the number of hours to avoid reading. But
Okay.
I'm not even sure that that's what you wanted to read.
No, that's the second point, which
Yes,
is that
yes.
the discrepancy in the time.
The hours were much longer
Yes.
than what was.
So it's two. It's the time of departure and then the time of return, which was about.
And the fact that they did not depart together, which is what was in the first affidavit.
The first one was the we that I'd emphasized. They did not depart together. And the second thing is that they did not consult together either with the doctor upon return. And then the final thing is that consultation took place much later at night than just after 5 o'clock. The deponent also corrects the facts on the travel on the 9th and 10th June to the northwest. And what, yes, those really are the main things that I wanted to make clear from the first deponent's affidavit. The final thing I'll say is that she does also confirm, and that's at paragraph 20 of her affidavit, and this is important given the replying affidavit that came later last night. Paragraph 20, is that, yes, page 65, where the deponent confirms in the middle of the paragraph, I am unable to identify every such occasion, and that is travel and leave excursions from the facility. Subject to this qualification, she says, I accept that the geolocation data generally reflects my husband's movements. I do not dispute the accuracy of the data or seek to explain it away. We've explained in the answering affidavit the analysis of the maps and the geolocation data and what they show. And what they show is that almost every single day, Mr. Karim leaves the facility. And that on most days, he's out of the facility for at least 8 hours, sometimes longer. So which is what my learned friend was objecting to, the inverse inpatient reference that was made in the answering affidavit, was that he spends more time outside of the facility than he does inside the facility, is really the point of that. So what we get now is a materially different picture from what we first had. And when I say what we first had, I'm saying let's go back. I'm not going to do it now, but if you go way back into history from April, the picture keeps fluctuating. And it fluctuates recently when Mr. Karim's, when the deponents are provided with objective information from the commission that changes the version that they initially gave. So that information is not information that is in our knowledge. That's within their knowledge.
Please continue.
So what the crux of the point here is, Chair, is that these shifting accounts in the affidavit are important because they show that each time that the deponents are presented with, confronted with objective evidence concerning Mr. Karim's movements, the explanation changes. Second, and this is important because of the ruling that we seek from the Commission, it underscores why an independent medical opinion is now imperative. And without impugning their doctor's integrity or professionalism, it's apparent that he has not been placed in full possession of the facts concerning Mr. Karim's comings and goings from the facility. So his own medical assessment and the report that was furnished to the Commission appears to have been based on a flawed factual foundation. So that's another reason we say that the independent medical opinion is required.
The doctor, you've referred us to 4841, where the doctor states that a patient may only leave the and underline only in one of two ways, which is a pass by the doctor. And also if a patient wants to discharge themselves. But in the later, should I call it what, a supplementary affidavit? Yes. In that one, the doctor now makes a suggestion that other people may, I hope I understood it correctly, other people may, I don't know whether actually issue passes or allow a patient to go out, but other people now are involved, whereas in 40 he said only only one of two ways, a pass by the doctor or.
So now what the doctor says, and it's at paragraph 16 specifically, is that if he's not available, then the nurses will authorize.
That's the point I'm making. Thank you. Yes.
So which is a very fundamental change from the first affidavit. You don't need to have been presented with this data that we provided him with of the geolocation of the phone and the movements that we obtained independently in order to make an accurate statement from the get-go about how movements take place in the facility.
And it is quite telling that you have these movements in the allegations on Mr. Karim's side, not by one person only. The second wife also moves or changes her allegations once confronted by facts that contradict what she says. And unfortunately, this is happening with the doctor as well. A patient may lawfully leave the facility in only one of two ways. But later, once we have the geolocation and the times when Mr. Karim would be out of the facility, and suggestions of much, much longer times than what we were made to, or given to understand, the doctor as well, just like the first wife, moves and changes, and now tells us about the possibility of nurses also issuing passes.
So we didn't ask for the specific question of passes to be addressed in the founding affidavit. That was done of the doctor's own volition. So if the doctor is providing an account of how the system works, why was that not part of the account in the first place? Why did it come up only when presented with different evidence? The second thing is that, and that's why I read it out earlier and said he said so in terms that the facility records will show entry and exit. That changes in the second affidavit. And you'll find that at paragraph 18 of the supplementary affidavit.
That's at page?
Page 84, I'm told. So just paragraph 16 on that page is the nurses. And then paragraph 18 is where the doctor explains that, in fact, what he said wasn't correct because the facility protocol is not followed, that, in fact, the practice of keeping records is that it's just not honored. There aren't any records. The doctor also tells us that he himself doesn't keep records. He doesn't keep his own notes of when he issues or authorizes pass-outs. But he only tells us that in the second affidavit. Sorry. Bear with me, Chair, please. I'm trying not to make a mistake again, so I'm going a little more slowly. The most charitable interpretation of the doctor, he is relying on what Mr. Karim tells him about his movements. He now knows that he's not being told the truth about the movements. But all those facts were the facts that he based his information on when he gave us these reports. Those reports do not hold true anymore. So my learned friends...
although that charitable interpretation would not apply to the categorical statement that doctor makes, which is people go out only, and he specifies the circumstances under. Yes. So your charitable interpretation cannot apply.
Maybe I'm being too charitable. But the point
I'm not suggesting you should not be, but I'm just saying it cannot apply to that categorical statement.
No, it can't. Nor to the. I'll leave it there. I agree with the chair on that. My submissions are more to what it means then for the opinion that he expresses, in which he says to the Commission, this is the difficulty and again, what I wished to say at the outset was that the point of it is not to challenge the diagnosis. It's to say, what we're concerned about is functionality. What is Mr. Karim's ability to engage with questions and information and evidence that may need to be provided to the Commission? That's what we're concerned about. We're not concerned with dislodging anything else, although it may become necessary, and I'm not going to preempt the independent medical assessment that will come. That will give us a better picture, of course. So we can't rely on that. So to say that this report by the doctor is definitive falls on that basis. But the argument that the doctor's report is definitive is also extraordinary for another reason, because it itself is a breach of the professional guidelines that are referred to by our doctor in his affidavit.
I assume you will obviously address the issue raised by Mr. Premhid, that applies in the context of forensic what? Yeah, which Mr. Premhid submits. That's not the instance here.
In fact, it's exact opposite. It is exactly the circumstance here. I'm coming to that doctor's report, but it's precisely, those guidelines were prepared for precisely the scenario that we're facing today. So I'll come to that. For now, what I wish to say...
I must say, I didn't quite understand why this is not forensic, and which is why I put the question to Mr. Premhid, but we'll hear you when you get there.
Thanks, Chair. What my learned friend argues is we must accept the opinion of their doctor. That opinion, as we will see when we get to our experts' report, is provided in breach of those guidelines, those professional guidelines, which say that a treating doctor should not be the person to provide an independent assessment, and of this is the critical thing, of the individual's, the patient's capacity, which the commission is expected to consider, right? The objective determination of the capacity. So we're not talking about diagnosis, but it's about objective assessment of that person's capacity to participate in these proceedings. The guidelines say that it should not be provided by the treating doctor because the treating doctor is inherently subjective and an advocate for the patient, and I'll come to it because he says more things, and I'd rather refer directly to what our expert says. But so that's the thing. This is the first thing, right? But we must accept it, says my learned friend. And then what they say is, and with the support of their doctor, they say that then the witness must be insulated from any examination by an independent specialist. And no one is able to then assess whether that conflicted, what we say is a conflicted determination of capacity by the treating doctor is in fact reliable. Because we've gone through the passages, I'm not going to go back there, the paragraph 73 and 73 of their doctor's affidavit saying that there should not be an independent examination. I don't know yet where we stand on. I know there was a discussion about interposition of another physician, etc. That's not what we are proposing in any event. We're proposing something that is entirely squarely within the professional guidelines. So they say, and they've been saying to us, and Chair, let me just say in response to the question you posed to my learned friend about, I
wanted to, don't forget the point you wanted to address now. But I wanted to say, is it not semantics to say the IM, is it E?
Yes.
That the IME issue differs from interposing a different doctor. I don't quite see the difference you appear to be seeking to draw, because you would still be bringing in a doctor that's not the treating doctor.
That's right.
So why you would say that's not interposing another doctor, I don't quite, it's not a serious issue really. It's
maybe not, but it's important because we want to address the concerns that have been raised.
Okay, all right.
And it has been addressed by our expert, who explains that doctor doesn't take over the treatment of the individual.
The suggestion about interposing is not about this doctor that's being interposed, taking over. It's not about that. It's just for purposes of also doing an assessment.
Yes.
With a view to either confirming or not confirming what the treating doctor has said. So I'm not quite sure that I get. I still do not get the difference you are saying.
Okay, that was my understanding of the difference. But if the interposition goes to what the chair is now saying to me, which would include that, well, then
that's all I meant
right.
when I used the word interpose. That's all I meant.
Well, what the guidelines say is that it's not only permissible, it is required that there is an interposition then, in the sense that there's an independent assessment that's testing for a particular outcome, and that's why it's forensic. So
back to your point then, the point you wanted to make. I hope you have not forgotten it.
Well, Chair, oh, yes. Chair, you posed a question to my learned friend about the lack of a response to the evidence leader's request for an independent examination, and we've set it out in the answering affidavit. There was a correspondence from I think, May, if not earlier, in which that was requested.
And don't forget that correspondence was preceded by an undertaking by Mr. Karim sitting in that witness box. So there's that, and then the correspondence.
And then the correspondence, which went unanswered on that point. We did get answers to other parts of our correspondence, but not to this. It's in our answering affidavit. This history is set out. Until we pressed for an answer on whether they would agree to an independent medical examination. It culminated in the hearing that took place, I think, on the 25th of June, which was the debate that you were having with Mr. Premid about what exactly was said in that hearing. And I think on that score, I'd rather just go back to the transcript and have a look at it. Our understanding was that there was an objection to an independent medical assessment. And it was quite plain in our understanding, but we can go back to the transcript and have a look at that.
May I request both counsel to finish us, say not later than the end of day tomorrow with the relevant part of the transcript?
Certainly, Chair.
Thank you.
So what we're told is, accept our guy, accept what his say so. No, you can't have an independent assessment. And then it gets even more absurd, because the next claim is that no one is able to assess, the treating doctor's determination is unanswered. As we heard, well, it's unanswered, it's unchallenged. And so it must be accepted. So it's a circular reasoning in which...
It's exactly for that reason that I said it cannot lie in Mr. Karim's mouth to say this is unanswered.
Yes.
Not in the face of what I understand to have gone on, but as I said, I accept that my recollection may be inaccurate.
Well, let me say this. I've not heard, and we know because apparently there was a need for an instruction, so there was never a response to that at least from my learned friend's perspective, there was never a positive response to this, which is yes or no. So why not? That's the question. After so many requests, the stonewalling is no independent medical assessment, and then it's triumphantly, but you see, our doctor's unchallenged, and therefore you have to, and you, the commission, must be now bound by that doctor's assessment. So I think what I should now do, and I would say this, that if their doctor had given a response to our doctor's affidavit, we might have also, perhaps this would have been there would have been a shortcut through this. But there is no response. Our expert is unchallenged, in fact. And I'd like to go to our expert's report. What page is it Page 125 is where the report itself.
Please be careful what you read.
So I'm going to go very slowly. And I think what I will do is just refer the commissioners and my learned friend to paragraphs of the report and try to deal with it in that way. But what I want to begin with saying is that this expert has attached his CV. He is the former chair of the professional association that regulates the very field in which their doctor practices. He's extremely experienced, and he is the co-author of the guidelines that he refers to in this report. I'd like to go to page 126, paragraph 5.
So maybe before you do that, if you could just refer to, without necessarily reading it, paragraph 3, because it sets out the purpose of this report. And I think it's important on the back of Mr. Premet saying that this expert has not countered.
Well, yes, no. So this expert was not asked to do an assessment on paper of Mr. Karim, nor could he have been able to do so because all that he was provided with was their doctor's affidavit. And their doctor, which is something that I should actually point out because it does go to the reliability of that report, doesn't set out the details of things like the treatment protocol, etc. And I don't want to say too much more about that, but there isn't that kind of detail in any event. So it wouldn't have even been possible for our expert to give a meaningful opinion based on that affidavit, which wasn't setting out the full details of the condition. So what he was asked to do instead was to comment on whether the objection, on whether it is clinically appropriate not to have an independent medical examination. That's what he was asked to comment on, and specifically to comment on the objections that were made by their doctor about the interposition or whatever the interposition is defined as. So there was no request for it, Commissioner Baloy. And he would not have been able to do it even if he was requested because of the lack of information. And so what he does at paragraph 5 is consider the affidavit and the objections. And in paragraph 7, you'll see that he respectfully disagrees.
I noticed that your time is up.
My goodness. Chair, I now have to claim equality of arms.
Sorry, by how much did you overrun, Mr. Premier?
51 minutes.
No. I'm not talking. I'm not talking. Remember, right at the end, after Mr. Premier had said he was done, I'm referring to that stage. Not when we then engaged him, after he had said he was done. So the overrun relates to before that lengthy...
Yes, it was 3 minutes or something like that. The additional 50 minutes comes from the panel's engagement with me.
No, I'm not even counting.
Agreed. So equality of arms is 3 minutes, they're not 51.
Miss, how much longer do you want to be? Considering fairness to Mr. Premier, I may have to increase the 15-minute reply, time for reply.
A very charitable approach, Chair.
But how much
I'm indebted.
How much do you...
what I'll try to do is spend less time on the legal principles. They're set out very clearly, I think.
Take that as read. Take those as read.
So may I have 10 minutes, Chair?
All right, 10 minutes then.
And if I can do it in less time, I will. And one way to do it is to refer the commissioners to the paragraphs, the relevant paragraphs of our experts' affidavit. The statement, it speaks for itself.
Yeah.
The disagreement is in two respects. One is that it disagrees that an independent opinion should not be obtained, and second, he disagrees that if there were to be an interposition, that there would be therapeutic harm. In fact, he says not to do so, to require the treating doctor to provide the opinion threatens that therapeutic relationship between the doctor and his patient. So I'm just going to say paragraph 10.
At page 127.
Page 127, if the commissioners could just read paragraph 10. I can't deal with it reliably, it would be too risky, but it explains why the independent medical examination has become part of the necessary part of the guidelines, because you need an objective view in the context of.
Okay, you've made the point that it deals with why. We'll just focus our minds on that.
Yes.
You don't need to go through it.
And specifically, just one sentence, these challenges, I'm not going to say what the why are the challenges, but these challenges, if you read in the middle of the paragraph, may hamper the goal of insurers and the courts making sound decisions.
All right.
And then I recommend paragraph 11 at page 128.
Okay, we see that.
And paragraph 14. And then finally, paragraph 19, the conclusion.
Got that.
Then, Chair, what I would also commend to the Commission is the actual publication, which is attached to the report. I'm not going to go there. It's a minefield. There are just bombs all over it, and I don't want to make another mistake, but it's an important report. What I want to say about that report, it's published in a journal of the field, is that it's authored by several highly regarded experts in the field, and it's...
I saw reference to it saying international, am I mistaken? Or am I thinking about anything? I did not see peer-reviewed.
I believe it is a peer-reviewed journal. Okay. But I could be, I'll stand to be corrected, and I can double-check whether it is, in fact. It is the journal of the profession. Mm-hmm. It's accredited, I saw that. Mm-hmm. I can't remember if it said peer-reviewed.
In our field, in the legal field, it would never be accredited if it is not peer-reviewed.
Indeed, indeed so. So, and the one other thing you might have seen is the reference, because part of the literature, this is not a purely South African approach, these guidelines. So this report, these guidelines that are published in the journal also rely on medical literature from other parts of the world. And we referred to one, in fact, we pulled out an abstract of that article for the assistance of the Commission to show that this is not something that is unique to, it's not something that comes out of Mr. Expert's head. I'm stopping on that now. Yes. All that remains then for me, all that remains then, this is the most harrowing submissions I've ever had to make given the constraints of the ruling. And so I'm going to now draw to a close very quickly, because all that remains for me to say is that we've set out the authorities. The closest analog is the Kwelane judgment by the Constitutional Court. It's in our heads of argument. That judgment also cites very established principles on postponement, which requirements of postponement applications, which I have no doubt the commissioners can recite in their sleep. But importantly, what it says is that if there's a request for a second opinion and an independent medical opinion, that should be permitted. And the foreign authorities support the same, and then of course Michael versus Linksfield and so on, that a commission and a tribunal and a court are not bound by an expert opinion. The foreign authorities are useful because they are in a similar field as to the condition with which we are dealing with here, and it explains what the standard is for sufficiency of evidence and, importantly, independent expert evidence on the issue. And so I commend to the Commission those judgments. And
I wanted to clarify your expert's report, because you refer to it in the evidence leader's affidavit. You say there's no reply to what you refer to.
There's no reply to our expert.
Yes.
That's correct. I mean, other than what we've heard from Mr. Premid, I mean, their doctor, their expert, hasn't challenged the affidavit. So, Chair, we request that a postponement on the Never Never must be rejected. We request that the 14th of August be fixed as a date for Mr. Karim to appear, and that in the intervening period, that there is an appointment of an independent medical examiner who will provide a report, and that might affect then the date of the 14th of August, but at least it will be on the basis of an independent expert. Thank you, Chair.
Thank you, Ms. Sim. Can we take a short adjournment? I won't indicate a time. We'll indicate when we are ready. Let's adjourn.
Mr. Premier, 20 minutes.
Chair, very generous.
Thank you.
Chair, can I start where Ms. Hassam ended, that there's apparently been no reply to the Commission's experts' report? You'll find that reply at paragraph 16 of the replying affidavit at pages 334 to 335, which I'm not going to read for obvious reasons, except to please point your specific attention to what is said at paragraph 335, on page 335 at paragraph 17 and paragraph 18. Because with all due respect, several inaccuracies have been raised about the quality of the affidavits and the reports presented by the treating doctor. And even though my learned friend says that the Commission is not impugning the treating doctor, in effect, that's exactly what they're doing, both his bona fides and his clinical expertise. And in the affidavit that is filed and those paragraphs and pages I referred you to, and that it's confirmed by the doctor himself, that's the full answer. In fact, what our doctor says in response to their doctor, if I can use that phraseology, is that it actually confirms our doctor's position, which is if there's going to be any such interposition, that our doctor has to be involved in that process. And in fact, if we read their doctor's report, their doctor says exactly the same thing in terms. If I'm not mistaken, at paginated page 129 and paginated page 130, this is of their doctor's report, he actually says the following: the Commission should even advise the independent doctor that the treating doctor is the treating doctor, wishes to be engaged by the independent doctor. And he goes on to say, in my experience, I have done something similar. He goes on to say at page 130, it is my opinion that the engagement between the independent doctor and the treating doctor should occur before the interview by the treating doctor, the independent doctor, so that the independent doctor understands the treatment plan, etc. So the point is, and this chair goes to that IME forensic distinction, is to say the kind of exercise that the Commission's doctor is speaking to is a different exercise to be performed by an independent clinician. Our doctor has never pretended once to be performing an independent medical assessment inquiry. He is the treating doctor, and he's giving his clinical opinions. And this report does not dislodge that. All it says is that if there's going to be the subsequent process, this is how it must be, it must occur. And whilst I'm there, in response to this question about the instructions and why was it never responded to voluntarily or not voluntarily, when Chair and the Commissioners read the correspondence bundle, you'll read the correspondence bundle at page 123, going on to page 124. And at page 123, all I'll emphasize is that paragraph 10.1, which says, before our client takes a final position on the Commission's request for independent examination, the evidence leaders are required to identify a series of things, and then over the page, it goes on to 10.2. I only highlight that because it's not as if it's accurate to say that there's been no response. Consistent, Chair, with the debate that we've had before, can it be voluntary? Can it be compulsory? Do you have a power to even order a voluntary one? Those are what those questions are directed to. And with all due respect to the Commission and the evidence leaders, there hasn't been a response to that. So never mind what I put on the record earlier regarding the medical incident of my client when an instruction was to be taken. It's actually the evidence leaders who haven't responded materially to those questions, which my client expressly says through his attorneys will allow us to take a final position on this question of the medical examination. Because of course, Chair, if there are insufficient answers to those questions, particularly the question at
10.2 in bold, which is on page 124, statutory authority, it doesn't matter whether it's voluntary or compelled. If you don't have the power, you don't have the power. That's an ultra vires question, admin law 101. So on the question of whether there's this medical exam or not, that's the fullness of the answer.
That's exactly the level at which you and I engaged the virus
Correct.
question. Is there a power?
Correct.
And in a sense, once that issue is raised, you have no power. That would supersede or not the conditionalities at page 123.
Correct. It would. But the point that I would make in that regard is that if the Commission believes it has the power, then it must exercise its power and do so. But we can't be caught in an endless loop where the question is asked, where's your power? There's no direct answer, and then you get accused of not answering the question or giving a position where knowing the source of the power is a fundamental issue that requires clarification. And obviously, if the Commission decides it has the power and makes such a directive, and there's a challenge to be raised to that power and the exercise of the power, then the challenge will be raised. But it's all this indirect inferential reasoning rather than directly dealing with the issues that I'm raising here in the context of what I've just flagged with you, Chair. That takes care of a few of my submissions. Let me move on to the next few. What my learned friend said at the beginning of her address is that it's an extraordinary claim that we've made that our client is unable to give the information that was sought as far back as March. Now, I'm not going to argue the point. I'm just going to direct your attention to medical opinion, which has not been contradicted. The first of that medical opinion you'll find at page 37 of the record, paragraph 26. And I would emphasize that when you read, look at what it says as lines 2, 3, and 4, starting with it materially and ending with the words identified triggers. That's medical clinical opinion as to what or why the information can't be given.
Mr. Premier, this doctor only saw your client from when? Because the period from March until 13 April, he cannot express an opinion on that. He simply does not know what the position was. He was not there.
I'll respond to you in 1 second, Commissioner Khumalo, if I may. Commissioner Khumalo, I've asked Ms. Madlanga to find a particular reference for me that answers your question, because my understanding of the doctor's position is that the phenomenon the doctor observed, diagnosed, and treated after he came on board as the treating doctor suggests that actually the condition could have arisen and materially impacted Mr. Karim even prior to when it was diagnosed and treated thereafter. So I accept your
Yeah, but that's speculation.
Well, it's, and with all due respect, I'm not sure if you can say that having regard to what the doctor has himself said, but be that as it may, if it's speculation or if it's not speculation, that can be tested. And the point of the matter is the doctor's view is that what I've observed from the incident when I came on board onwards suggests to me a long-term medical issue which may have impacted things before. I can't take it further than that. So I gave you the first reference to page 37, paragraph 26. The other reference I'll give you is on page 96 at paragraph 51. And I would ask you to start reading from about midway in that paragraph. In the 8th line, when it starts with the word when. And I would ask you to read after that next sentence in the 9th line that starts in a state of blank, and then it goes on to speak what a consequence of his giving information in those situation might result insofar as accuracy, reliability, recall, or anything else is concerned.
At what line do you stop? Below when? Below the line starting when? At which line do
I'm
you
saying
stop?
the entire paragraph, but I was emphasizing those
okay.
particular portions, the one starting when, the one starting in a state of blank.
Okay.
And then the next one that starts with any information. The last reference, or second last reference I'll give you, is at paginated pages 48 and 49. I think we've been here already. We've gone through these paragraphs. I'll just give you the places where I would like your attention, please. Just look at what is said in paragraph 65 at the end of paginated page 48 that starts with, I had raised this concern. And what he says at the end of that page, interaction, words, 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 until the full stop. And then I would say when you're looking at page 49 at the top, still paragraph 65, look at what is in the third last line that starts with rather, and what the conclusion is regarding any information that may have been given or may have been procured. Whilst you're at page 48, 49, please also look at paragraph 63, and then what follows. Commissioner Kumalo, I say expressly, I don't think that answers the challenge in the way that you put it to me, but I've asked Ms. Madlanga to find that reference. The pressure is on her now.
From 4 May, I get it.
Yes.
But from
No.
March, April.
I know. But what he does not say, importantly, is that the phenomenon only started on 4 May onwards, because it's an ongoing phenomenon that he's treating. But I take the point, and that's the response to you. You've already heard me on, are we impugning the doctor or aren't we impugning the doctor? May I just say this? This doctor has made himself available to the Commission in numerous instances. And the peculiarity of what we're dealing with here is if you took one step back from listening to my learned friend's submissions and my submissions about who's expert and whose expert is correct or whose one's medical opinion is of greater validity, you would almost be in a situation where we were in a trial where you were cross-examining two experts and running two experts' evidence against each other. As in expert against expert, not even expert against expert in respect of Mr. Karim himself. The only reason I point to that is that if that's the Commission's real concern, then the elephant in the room is they think that the doctor is a liar, and they have the weaponry available to them to test whether he's a liar. And all these inaccuracies, whether they're of a material kind or not a material kind, I see Chair is getting ready, maybe I should stop.
Please, you overdo this thing of reading what a person does. I mean, should I not lean over? Should I not place my hand on my file? Please, Mr. Premier.
Oh, sorry, Chair, I thought you were going to engage me on what I was saying. That's why I preemptively stopped. I also have the other problem when the judge is trying to intervene and I don't then yield.
I remember at the Constitutional Court you reacted to 2 of my facial expressions.
Yes, indeed. But I don't mind that because you found for me on that occasion, so that's fine, Chair. Unlike what happened in the interdict yesterday, but that's besides the point. Chair, what I'm saying is that if this doctor is so unreliable, or his evidence is so open to doubt and to question, why on earth would this doctor under oath volunteer himself to come and give evidence and be cross-examined under oath? The approach of the Commission, with all due respect, has not been to take a benign or neutral position towards Mr. Karim, the deponents of Mr. Karim's affidavits, and even the treating doctor.
it's been that, and I'm speaking in forceful language, but I preface what I'm about to say with the fact that my learned friend didn't put it in these terms, but this is the conclusion, and we must call it out for what it is. In their view, the evidence leaders' view, Mr. Karim is avoiding accountability at all costs. He's using the deponents of the affidavits and treating clinicians to aid him in order to do so. And that's why they want to unpick, with all due respect, the most direct medical evidence in front of the commission in order to go after Mr. Karim. But the one thing they haven't done is they haven't called the doctor to be cross-examined by them, and he's volunteered himself to do so. So that's why this weird world in which we exist, with all due respect, is a difficult one for Mr. Karim's legal team to have to engage in, because even when the doctor volunteers himself, instead of bringing a rebuttal witness to directly deal with his clinical views, which is a possibility they could have done, or by calling him through a subpoena to come give evidence in camera and be cross-examined, they want to put up all kinds of geolocation data and CCTV footage to impugn the doctor's medical views through the back door where there's no clinical basis to do so.
No, Mr. Pramit, I think it's grossly unfair that you would formulate the position of the evidence leaders to impugn the medical opinion. They are lay people. They're lay people. They could never pretend to do that, and I've not understood them to be doing that. That is different to speaking to the facts alleged by the doctor. When the doctor says the hospital protocol is that you can only leave in two circumstances, that's not a medical view that he has expressed. He's alleging a fact, and it's relevant information to be brought to the attention of the commissioners through the commissioners through the evidence leaders, and the geolocation material, as Ms. Hassan says, what has always been the impression is that Mr. Karim is in hospital. He's confined to a hospital, right? And once there was information that, in fact, he doesn't spend all his hours in a hospital, that's relevant information to be brought to the commission. So you have absolutely no basis to criticize the evidence leader's position as being to impugn the medical opinions of the medical conclusions and opinion of the doctor. I would be shocked if that's what they were doing.
Me too, with all due respect.
My first question would have, and that's not what is in the papers. My first question to Ms. Hassim would have been, on what basis? In the same way, in fact, that I would like to ask the question, the deponent to the replying affidavit is a lay person. On what basis could she pretend to answer the commission's expert views, as you have referred us to a paragraph, right? Is that an answer really in response to the concern raised by Ms. Hassan that there is no reply or answer to the commission's expert? So let's not fudge things for whatever purpose we're seeking to achieve. As I see it, or as I understand it, the simple position is this: there are certain facts that have been relied upon by the deponent to the affidavits of Mr. Karim, supported by the doctor's affidavit. All that has happened is to answer those factual or to raise issue with the facts as set out, and none of it speaks to the medical conclusions. I differ with you there. Maybe my co-commissioners agree with you, but I differ with you. I do not see that.
I actually agree with Commissioner Baloyi. What the evidence leaders have done is to say Mr. Karim must be subjected to an assessment by an independent doctor. And that's exactly because they, as evidence leaders, cannot purport to contradict the Mr. Karim's doctor's opinion. That is why there's this insistence on let Mr. Karim be subjected to an assessment by, it would be that independent doctor that would counter all of the clinical conclusions reached by Mr. Karim's doctor. So at this stage, the point you make has not been reached, at least not on my understanding.
Well, but
yes.
Sorry.
But of course, a point is made, but on what Commissioner Baloyi refers to as facts. A point has been made that with regard to those facts, even what Mr. Karim's doctor says, there has been a shifting
Yes.
of the goalposts, even by the doctor
Yes.
himself. That's a factual issue, and the evidence leaders are perfectly entitled to challenge the doctor on that.
I accept that, but then I would ask, my next question would be to what end and to what purpose? Because on the question of factual discrepancies, both of the deponents to the affidavit full square deal with the circumstances under which they were expected to depose to affidavits and the pressurized circumstances that they had to deal with various issues. And that's explained at pages 75, 76 for the one deponent, and with the other deponent, specifically on the medical records issue, you'll find that at 84, 85, and 86. So if there's an issue about the facts, so to speak, and the conclusions or the inferences that the commissioners are being invited to make as a result of these so-called inaccuracies, there's actually an explanation.
They are not so-called. They are inaccuracies, and Mr. Karim's case, as we sit here, actually accepts those, that they are in fact inaccuracies. Hence the shifting of goalposts. So they are not so-called.
I withdraw the word so-called. To the extent that there are inaccuracies on the papers, they're dealt with fully, and the surrounding circumstances around how those inaccuracies arose are fully dealt with. It's not uncommon in urgent applications, for example, that sometimes a deponent doesn't fully remember what it is they otherwise ought to have remembered. And it's only when they are advised of something in an answering affidavit that then in the reply they give the fuller account and context because of the pressured circumstances in which they were deposing. So all I'm saying is that let's accept the inaccuracies are for what they are. It's maybe unfair is too strong a word, but it's unfortunate to draw any adverse inference by the mere fact of those inaccuracies in circumstances where there's also an attempt to explain how those inaccuracies arose. But to the extent then those inaccuracies relate to movement and what can be said about Mr. Karim's medical condition as a consequence of the facts of that movement, it's not a purely factual inquiry, because what the doctor says in terms at paginated page 44 of the papers, at paragraphs 49 and 50, is he says that the danger in analyzing the facts of those movements would potentially lead you to draw an inaccurate clinical conclusion, because the fact of those movements is not necessarily antithetical to the treatment he's receiving. In fact, in another part of the affidavit, he actually says that it might form part of the therapy process. So I accept what Commissioner Baloyi puts to me. Commissioner Baloyi rightfully says that they're not impugning his clinical diagnosis, they're just relying on these factual issues to say there's a problem here, and I'm being loose in my language. And so let's accept that there's a problem here, and then say what's the clinical opinion in respect of that so-called problem that's on the papers in front of you and not challenged. And that's what the doctor warns the commissioners, from drawing an inappropriate conclusion on, that those mere facts are elevated to considerations that impugn, or not even impugn, that open to doubt the clinical diagnosis, even if that's not the direct intention of disputing those facts. And what the doctor's evidence is regarding those facts is that they are what they are, and they might be what they might be. But you can't draw in, based purely on those facts, you must be very careful in what conclusion you draw. And I'll put it no higher than that. So I think that's where Commissioner Baloy, I was dealing more with the conclusion and the conclusions to be drawn from those facts, whereas I think, Commissioner Baloy, you were focusing on those facts themselves, and I hope I've attempted to answer you in both respects why there's a danger in the exercise that we were just going through. Yes. Oh. I thought Ms. Madlanga had something for me. She doesn't. So that's on the issue of are we impugning or are we not impugning, and to what extent are we impugning? Just, Commissioner Baloy, one thing that you raised, which is correct, the deponent is a layperson. What business does she have engaging with the report? If I'm not mistaken, there has or should have been a signed confirmatory affidavit from the treating doctor in respect of the content of the replying affidavit. And even if it doesn't say it in terms, I consulted with the doctor on X, Y, and Z, and he tells me, here's the response. I would ask, in a generous reading of that replying affidavit and the fact that it's confirmed by the doctor, that the so-called medical responses are medical responses from a non-medical person, but confirmed by the medical person themselves. It's not just the deponent offering her own opinion or thoughts influenced by the legal team or anybody else. So that, Commissioner Baloy, I hope is a satisfactory response on those particular issues. Chair, I think I've dealt with everything that I need to. Might I just take an instruction, please? Oh, yes. I'm indebted to Ms. Madlanga. Commissioner Khumalo, back to our debate about the timeline and the date and when it started and everything else. The reference I had in mind starts on paginated page 36. It's the heading you'll see there under paragraph 18. And then through you, Chair, Commissioner Khumalo, over the next page, well, it starts at the bottom at paragraph 22.
18 says exactly what I said.
Yes, agreed. And then I'm asking you to read 22 at the bottom of that same page, particularly where it says health conditions appear to predate the commission. It then talks about his history. And over the page on page 37, I would say that I would draw your attention to the last line, starting 3 lines from the bottom on page 37, paragraph 22. It starts with, I emphasize this because the underlying blank, blank, blank. I know that might not be satisfactory to your question. I'm just giving you the reference that I had in mind when I answered your question.
It's also factually incorrect.
Thank you, Chair. I'm indebted.
Thank you, Mr. Premier.
Chair, may I ask a clarity, please, before we break up? In passing, you said that we must give by the close of business tomorrow the transcripts.
Just on your and my debate the last time on the power issue.
Yes.
Or lack of power, as you
yes.
argued. Yeah.
Yes.
Yeah.
Is
Just
it all right
that,
if...
Because, yeah, in the context of you talking about there having been no resistance, as I understood you, by Mr. Karim, to the possibility of voluntarily agreeing to an assessment. That's the context.
Yes, yes. Is it okay if we mark the transcript?
Yes, yes, yes.
Okay.
Please. Yeah.
Thank you.
Thank you to both counsel. Obviously, we can't make a ruling now, and I'm loath to give a deadline by which a ruling will be made. Let me just say, a ruling will be made on a date that will be announced by writing to Mr. Karim's attorneys and also being publicized in the manner in which our spokesperson ordinarily does. We continue on Monday, 9:30?
9:30 on Monday, yes, Chair.
Yes. Let's adjourn and resume at 9:30 on Monday.